Yes, Ms Phillips.
Commissioner, the first witnesses this morning will be giving evidence concurrently. They are Dr. Adam Gordon and Dr. Jack Green, but I should also indicate that that they are represented, and there are some other appearances for other parties who'll be giving, of other witnesses who'll be giving evidence today.
Yes.
Commissioner, I appear for Dr. Jack Green and Adam Gordon, SM Constable, CONSTABLE.
Thank you. And yes.
Commissioner Ms Cairns,
Yes.
CAIRNS. I appear for Dr. Dye.
Yes,
DA.
very well. Thank you, Ms Gans.
Thank you, Commissioner.
Otherwise, the appearances are... Oh, no?
Yes, morning, Commissioner. My name is Ben Jealous. I appear with Sonia Katz, with your leave, for Justice Untersteiner of AHPRA.
Yes, indeed, you have that leave. Yes.
Doctors, please come forward.
Excuse me.
Sorry, I don't understand.
Beautiful. Do you solemnly and sincerely declare and affirm that the evidence you give will be the truth, the whole truth, and nothing but the truth? Please thank you. My apologies. Adam Gordon.
Yes, doctors, do take your seats. Is there some reason we're taking the evidence conjointly?
Commissioner, the two representatives of the same organisation with different perspectives.
Yes.
Dr. Green, can I ask you to state your full name, please?
Jack Green.
You've prepared a witness statement that's dated the 28th of July 2026.
Yes.
Is the contents of that statement true and correct to the best of your knowledge and belief?
It is.
Commissioner, I tender that witness statement. It has doc ID stat.AHPRA.0001.0603 _R.
Yes, Dr Green's statement will be admitted as an exhibit.
And Dr. Gordon, can you please state your full name?
Adam Gordon.
You've prepared a witness statement that's dated the 28th of July 2026.
I have.
Is the contents of that statement true and correct to the best of your knowledge and belief?
That is true.
I tender that statement, Commissioner. It has doc ID stat.AHPRA.0001.0594 _R.
Yes, Dr Gordon's statement will also be received as an exhibit.
Dr. Green, can I start with you? You were raised in Melbourne's Jewish community, is that right?
Yes, I was.
And both of your parents were Holocaust survivors who lost most of their families in that event and came to Australia as refugees.
Yes, they did.
You're a volunteer guide at the Melbourne Holocaust Museum, and that's shaped a lot of your perspective about Jewish history, is that right?
Yes, it has.
And you're also a qualified dermatologist
I am.
and general practitioner.
I have both qualifications, yes.
And is it right that you have a private practice and that you also maintain public appointments at various hospitals as a consultant dermatologist?
Yes, I do.
You've commenced your witness statement by noting that in your own professional practice you do not display or wear political symbols, and that you do not initiate political discussions with your own patients, and that your experience is that this approach works. Would you like to comment on that?
Yes, so as a dermatologist, I have a particular interest in skin of colour dermatology. So a lot of the patients I see are from a different background to mine, quite a diverse population. Many of them have been refugees themselves from various parts of the world. And in my own practice, seeing this varied population, I do not discuss politics. I think that cultural sensitivity is very important, and basically the patients are there to be treated. I'm their doctor, and that is the most important thing. It's a trust relationship, and there is no place for politicization in health practice, and that's the way I've been practicing for a long time, and I've never had any problems, and it's worked for me and it's worked for my patients.
And Dr. Green, by reference to paragraph 9 of your witness statement, are you able to tell me about the Australasian Jewish Medical Federation and your own role in that organisation?
Yes, I've been the president since 2019. The organisation was an amalgamation of medical organisations both in Victoria and New South Wales, and the origins are different and quite interesting. Refugee medical practitioners who came here in the 1930s from Nazi Germany, from Austria, and then after the Holocaust from other areas, wanted to re-establish themselves, and if they were to retrain in Victoria, they needed to go back to medical school for 5 years. In New South Wales, it was 3 years. They flocked to New South Wales, and they faced a lot of difficulties and pressures retraining, and so they formed their own self-help group, New South Wales Jewish Doctors Society, in the 1950s. In Victoria, they were more locally trained doctors, and after the creation of the State of Israel, they created an Australian affiliate of the Israel Medical Association, also in the 1950s. Then in the 1980s, the two organisations amalgamated to the Australasian Jewish Medical Federation.
And you've said that in your involvement with the organisation, the AJMF, prior to the 7th of October 2023, the organisation hardly ever received reports of anti-Semitism within healthcare.
That is correct. I only ever dealt with one minor incident, and the organisation was past its heyday, and there was a lot less activity than had been in earlier decades. It did become busy during the COVID years, so 2020 to 2022. I'd set up a WhatsApp group, and there was a lot of discussion about the pressures of practice and issues to do with the pandemic. It was very busy, but there wasn't a discussion of anti-Semitism in that WhatsApp group. It just really wasn't there, even though it was quite busy.
And can you comment on how things changed for the organisation after the 7th of October 2023?
So after the 7th of October, I restarted the WhatsApp group, and this time a lot of people joined very quickly. It peaked at 450 individuals on that group, and what we were seeing were people were talking about lots of examples of anti-Semitism in the health sector. There was increased politicisation in the health sector. There was a lot of social media postings, and there was a lot of increasingly distressed Jewish medical practitioners, and they started contacting us, telling us some of these stories, and there was increasing need for advocacy.
Dr. Gordon, I might come to you at this point. Is it right, you were yourself raised in a traditional Jewish home in Melbourne?
Correct.
And you're a medical professional with a specialisation in gastroenterology?
Correct.
And you currently work in the private healthcare sector, but previously for over 20 years you worked within the public healthcare system in Victoria?
Correct.
And you completed your medical training at the Alfred Hospital?
Correct.
And you've said in your witness statement, this is at paragraph 6, that you had never experienced anti-Semitism in Melbourne before the 7th of October 2023.
Correct.
You've noted in your statement, this is at paragraph 9, that after the 7th of October you established a dedicated advocacy committee, which you've said was to provide support to Jewish doctors and healthcare workers who had experienced anti-Semitism.
Correct.
And is it right that you then brought that committee into the AJMF as a subcommittee within the Victorian branch of that organisation?
Correct.
And is it the case that you subsequently served as Vice President of the Victorian branch of the AJMF from about February of 2024 until December of 2025?
Correct.
Are you able to indicate why it was that you saw the need to establish the advocacy committee that you've described?
So I was a member of the WhatsApp group that Jack spoke to and set up, and there were a lot of doctors expressing that they've been marginalised, isolated professionally, experiencing antisemitism, and so there was a lot of despair on the WhatsApp group, and people were giving support to these people who've been having these experiences. But in terms of practicality, a lot of these doctors who'd been facing the system by themselves weren't achieving fair outcomes. And there were also doctors and other healthcare professionals who were experiencing antisemitism who were fearful of approaching management because of impact on their job, on their career, particularly junior medical staff who are in a very vulnerable position in the hierarchy in the public healthcare system. And so I felt that if there was a group that could speak for these people, we'd be able to get further than the individual speaking for themselves, who weren't unfortunately getting very far.
And Dr. Gordon, can I take you to paragraph 17 of your witness statement? You've noted there that you have observed through your role in the AJMF that there has been a pervasive sense of loss of safety or lost safety in the workplace and in professional networks amongst Jewish medical professionals, and a fear of displaying Jewish identity. Are you able to comment on how you've seen that arise and the kinds of behaviour changes amongst Jewish medical professionals that can accompany that sense of lost safety?
Well, doctors are afraid to display symbols indicating they're Jewish. So a lot of people have, Magen David or Star of David that they might wear on a chain, and people either conceal those kinds of things or don't wear them at all. They definitely don't broach topics about being Jewish in group settings at work, because that's an invitation for, discussion, confrontation about conflict and Jewish identity, and people are afraid.
Dr. Green, can I come to you, please? In your witness statement from paragraph 18, you've outlined several themes under a heading which reads incidents involving patients and healthcare workers. And the first topic that you address under that heading refers to media reports in February 2025 that healthcare workers were filmed making comments about refusing to treat Israeli patients. And I'm not going to ask you about the specifics of that incident, but can I ask you, by reference to paragraph 20 of your witness statement, what Jewish healthcare professionals shared with you about the impact of some of those reports on them and their circles?
Well, what was discussed was concern about trust in the healthcare system, both for medical practitioners and Jewish patients, and the concern that there would be some risk that they might not be treated equally and fairly in a health system. And we need trust in our health system for the health of that health system. And if there's if that's affected, if that's fractured, that's a really unfortunate situation. And this is what was being expressed.
And you've described at paragraph 21 of your witness statement a report that was made to the AJMF by a community paediatrician. Can you describe that report?
I might read that. A community paediatrician reported to AJMF that the father of a child he was consulting with, who did not know the doctor was Jewish, had told him that he had terminated the services of a National Disability Insurance Scheme coordinator upon learning that the coordinator was Jewish. The father is reported to have stated that he would never trust a Jew to manage his money. And this is an old trope, a Jewish trope, and it's unfortunate that we're seeing it here in the health system.
And another incident that you have referred to is a paragraph 30 of your witness statement, the hospital incident in the Northern Territory that AJMF became aware of that occurred in August 2025. What did your organisation learn about that incident?
So that was an incident in which the obstetrician was wearing a political symbol, a kafir-themed lanyard displaying a Palestinian flag, and the patient and the patient's partner were Australians. One of them was Israeli-born. And I'll just read this out. Observing overt political symbols associated with a current conflict in which their family and friends have been affected, warned by their treating doctor, caused the patient significant distress and raised immediate concerns about whether they would receive impartial and equitable care. And as reported to the AGMF, the patient attempted to raise her concerns directly with the obstetrician, but her concerns were not acknowledged, and this left the patient feeling excluded and unsafe in the doctor's care. Now, if it had been at that time unacceptable for that medical practitioner to wear a political symbol, then we would never have got into this problem where the patient would be feeling unsafe. It really fractures the doctor-patient relationship, and healthcare. That's just a negative for healthcare. And so, if there would have been regulations at that time and a culture of not allowing the wearing of those political symbols, then this would have been prevented. It seems pretty clear.
And Dr. Green, can I take you to paragraph 35 of your statement? You've given an example there, I think, of an instance where some of the boundaries that you've just been referring to about politicisation in the clinical environment were enforced to a constructive outcome. Can you explain what happened?
In this situation, it was a junior medical resident, and someone in the team spoke to the senior clinician in charge. It was all done quietly to say, well, and by this time there'd already been a directive from the Victorian government. This occurred in Victoria, that political symbols should not be worn. The senior doctor had a quiet word with the junior doctor, and that was the end of the matter. And it was dealt with very well, and it didn't have to be out in public. And if matters can be resolved in a non-confrontational way, I'm all for that.
And Dr. Green, if I can take you to paragraph 28 of your statement, you've said that from your perspective, social media presents a particularly difficult challenge because it occupies a grey zone between personal expression and professional identity. Are you able to articulate what you have in mind by that grey zone?
Well, people have a right to political expression. People have a right, of course, to express themselves, but as medical practitioners, to maintain trust in our system, not just medical practitioners, all health practitioners, there are restrictions compared to other work environments because of that trust, of that power differential between the medical practitioner and the patient, and we need to make sure that that trust is maintained in the system. I could give a little bit of a parallel in the legal system. There are also restrictions on legal practitioners or judges making public comments because you don't want someone coming up in front of a judge and that judge has a particular partisan view and they might not feel that it's fair. So there's some sort of parallel with that. And the other thing is that I think there's a difference in social media whether someone identifies themselves as a medical practitioner and where they're from, and if they don't. So I think there needs to be caution with that.
Dr. Gordon, can I ask you, like Dr. Green, in your own witness statement, you've expressed some concerns surrounding the politicisation of healthcare settings, and you've given some examples of that at paragraph 28 of your statement. What are the examples that you consider give rise to that appearance of politicisation of those spaces?
In terms of patients wearing, medical staff or healthcare staff wearing uniforms at protests and online posting, is that what you're referring to?
They are the examples that you see as involving the politicisation that you're seeking to.
And as Jack spoke to, in the healthcare space specifically, we're not looking to regulate private belief or prevent legitimate advocacy, but there always needs to be consideration with what's being posted and the risk to the patient. And we need a framework for, what can be posted and what can't be posted.
In your view, Doctor, if a medical practitioner identifies that he or she comes from a particular institution, a particular public hospital, for example, in a controversial social media post, that crosses a line?
I think if it's visible to patients and they're taking a particular view, that it all comes down to boundaries and what's being said. And that's where a framework's needed, I think, to define exactly what can be said and can't be said. But I definitely think there are lines, and it's a matter of where those lines fall. A patient needs to feel safe when they're seeking healthcare, as Jack mentioned. And if the patient sees something that's posted by a doctor from the healthcare system and the patient's interpreting, is the healthcare system safe or not safe based on that post, it needs to be not offensive to the patient. And I think ultimately the patient is the centre of the system. The patient is vulnerable. As Jack mentioned, there's a power imbalance. The power lies with the healthcare providers and the healthcare institutions. And we have a responsibility with everything we do. As doctors, we take an oath to do what's in the best interest of the patient. So there's this tension between, what's in the best interest of the patient and wanting to advocate for a political cause. And so we need to give close consideration to that tension, but the top of the list should be patient welfare. And if there's a significant risk to the patient from coming out of what's being posted, in my mind, that's the priority.
An area which has been controversial, I think, is where a medical practitioner who has spent some time looking after patients in Gaza reports his or her experiences on social media. In that circumstance, it only makes sense if the person identifies that they are a medical practitioner, albeit it would not be necessary for them to disclose where they are presently working. Do you have a comment about that, Doctor?
I don't find that in itself offensive. If they're looking to do good in a particular community, in a particular part of the world, I think that's to be commended.
Yeah.
But it shouldn't veer into antisemitism, that's the point. So statements about Jews or unfair statements about Israel that then reflect on Jews, I don't think that's fair. But I think the fact they're going and doing good in a part of the world is to be commended.
Yeah. Yes, I think, Doctor, you wanted to come in on this,
I
did you?
do, yes. Of course, working in Gaza is, there's no issue with that. That's a good thing. A lot of Australians work in conflict zones all over the world. And that's a good thing. But if you take that experience and you post it online as a doctor and you connect that with false and misleading information, or some sort of selectively picked information or exaggerated information to push your political view, now that might cross a line. So it really depends on what the post says.
Dr. Gordon, you've commented in your statement, this is at paragraph 24, on having some engagement with medical insurers regarding updating their educational material in relation to the safe use of social media and adherence to social media guidelines. Can I ask you this at a structural level? What role do medical insurers or medical defence organisations have to play in terms of promoting particular standards of conduct amongst medical professionals, especially in those spaces like the online environment?
Yeah. Well, we had discussions with AHPRA and with the medical board, and we said to them, talk us through the process. There's someone who's reported, they have a determination made against them by a national board, be it the medical board. What happens then? You make a direction, they need to be educated. Who does the education? Who should we be speaking to make sure they receive the correct education? Because often people are posting online very quickly. They're not thinking about what they're posting. That's just human nature. And they don't realise that what they're posting is offensive. And so sometimes they're not meaning to do harm, but it's an education issue. And I think it's very important that they receive the correct education. So we were told by AHPRA and the medical board that often the medical defence organisations are involved in that process and education of those people. And so we thought it was important to approach the medical defence organisations and just make sure what education they were giving. And if we could help just to make sure they were giving the correct education, firstly to help the individual who's had a finding against them so they understand what's happened and so they don't fall into that trap again. And also to protect the public who's sort of who witnessed whatever's been posted or happened.
And Dr. Gordon, can I take you to paragraph 12 of your witness statement? And you've referred there to some of those engagements with AHPRA that you've just mentioned regarding the handling of anti-Semitism complaints and the need for staff education. And you've also referred there to engaging with them around the use of a standard accepted definition of anti-Semitism. Now, just putting to one side for a moment what definition that might be, we'll come to that in a moment, why do you see the adoption of a definition of anti-Semitism as something that has value in the context of complaints handling in the medical space?
As I mentioned, our committee approached a number of regulators and we said to them, this is happening, help us understand why it's happening. And one of the issues that came out was that there wasn't a standard definition being used, and that was creating difficulty and inconsistency in how cases were being handled. So we said to AHPRA, being the national regulator, I think we need consistency and we need a standard definition that's used to help the system, to help healthcare practitioners and to help the public.
And Dr. Gordon, you've noted in your witness statement that AHPRA has adopted the International Holocaust Remembrance Alliance working definition of anti-Semitism, and you go on to make reference to the 15 national boards in Australia, and you express a concern in respect of the manner in which those national boards might conduct their adjudication functions. Can I ask you to elaborate on that concern that you've identified?
Sure. So we had communication with AHPRA at an early stage about the use of a definition, and they adopted, or they didn't say they adopted, but they were using a standard definition from January of 2024, and that was the AHPRA definition. Even though it wasn't formally adopted at that point, they made it clear in several emails that's what they were doing, and we thank them for that. But what was happening were people were being reported appropriately because things were inadvertently being posted that might be offensive, and the cases were seen by AHPRA and deemed to be need to come up for some kind of judgment, and the people would come to whichever national board, which is the body responsible for making the adjudication, and then they'd be dismissed from there and told there'd been nothing wrong, and they'd keep doing the same thing because as far as they were concerned they'd done nothing wrong because they'd been before the national board and told they'd done nothing wrong. So not unreasonably they kept doing the same thing, which unfortunately was the wrong thing to do because of it was offensive, and then they'd be reported again, and there was this revolving door situation where people were being reported. AHPRA said there's a case to answer, the national board would say that you've done nothing wrong, they'd be dismissed, and then they'd be reported again, and so on. And so we tried to work out why that was happening, and why that was happening was because the National Board is not under any obligation to, or the National Board's not under obligation to use the standard definitions that are provided to them by AHPRA. So the way the system works is, a case is reported to AHPRA, there'll be an investigator at AHPRA who'll put together the case and include standard definitions. So in cases involving anti-Semitism, that will be the AHPRA definition. It's handed to the relevant National Board, and then the National Board is judge and jury and makes a determination.
But the National Board doctor is making a determination of whether or not the doctor has breached his or her professional code of ethics. Is that broadly what the national
Correct.
body is doing?
Correct.
So the national body needs to be looking at the conduct of the individual, including presumably consideration of the intent. One would not find a doctor had engaged in anti-Semitic conduct if the doctor had not evinced a prejudice or hostility against Jews, would one?
Correct. But it comes to definition,
But,
in my
this,
mind.
this is the matter I'm taking up with you, Doctor.
Yep.
The definition is accompanied by examples.
Correct.
The examples are of occasions when expressive conduct might evince a hatred of Jews.
Correct.
One can't isolate, in the context of disciplinary proceedings, an example from a consideration of the conduct in its context.
That's true. We did meet with the medical board to talk about this issue, to try and work out what was going on and if there was indeed a gap. And so because they're under no obligation to even consider the definitions that are provided to them by AHPRA, and we couldn't discuss individual cases, so we didn't have insight into exactly what was going on, we had concerns that the reason that the cases were falling through the gaps was because the AHPRA definition wasn't being considered. So what we asked was, well, can you just make sure that the AHPRA definition is being considered? And as you say, if it's not anti-Semitic, then it's not anti-Semitic. But we just want to make sure they're using the right framework. And the framework we were asking them to use was the AHPRA definition. So there's an inconsistency in that the AHPRA is using the AHPRA definition, which is the framework, but the medical boards aren't under any obligation to use the same framework. And because of that inconsistency, we had this revolving door situation.
Dr. Gordon, can I take you to a slightly different topic, which is what you've said in your witness statement in connection with education, particularly education concerning anti-Semitism. You pick up on this topic from around paragraph 32 of your witness statement. Are you able to explain the way in which you consider that anti-Semitism education could be embedded within existing training programs or modules that doctors or medical trainees are required to undertake?
Yeah. Well, at present, there's a requirement to do in the workplace health and safety training. And as part of that, there's cultural awareness training. And I think anti-Semitism training is a natural fit into cultural awareness training. So that's the case in the workplace, and it's also the case in healthcare professional training programs. So I think it's a natural fit in both those situations.
And Dr. Gordon, is it right that your patient cohort in your own practice includes a number of Jewish patients?
Correct.
And are you able to outline any concerns that your patients have raised with you in the last couple of years around accessing healthcare or medical procedures in your practice?
I have quite a large Jewish patient population, and on a regular basis I have patients expressing concern about, I'm a gastroenterologist, so I do procedures in hospital, and people ask me, am I safe going to that hospital? And patients are in a very vulnerable situation, and particularly patients who are having procedures, they're essentially unconscious. You know, they're under an anaesthetic, and they're worried about what's going to happen to them. Firstly, are they going to be exposed to anti-Semitic sentiment when they go to this place? And secondly, am I going to be taken care of, and what's going to happen to me when I'm unconscious?
And are you able to isolate the time period in which these sorts of concerns first started escalating, insofar as they were taken up with you by your patients?
I had never been asked a question along those lines before October 7, 2023. And I've been in private practice since 2006.
And at paragraph 35 of your witness statement, you've said that given the loss of trust and the sense of safety amongst the Jewish community that you've earlier described, you consider that public healthcare services need to make visible commitments to the safety of Jewish patients and staff. What are some of the visible commitments that you have in mind there?
Well, I think firstly, the main visible commitment is removing political advocacy from healthcare, because that's a sign we're taking a stand. It's what's being done in Victoria, and I think it should be done nationally. Healthcare, again, is about the patient. The patient is the focus. The patient's vulnerable. Everything we do, we need to consider how is this going to impact the patient, and only do what's in the best interest of the patient. To do otherwise, there's this additional burden of a concern on the part of the patient. Where do I fit into this new entity, political advocacy? If I'm on the wrong side of the political advocacy, am I going to be treated fairly? And it's not just a issue relating to the Jewish community. I speak to patients from other minority ethnic communities, and also doctors from other ethnic minority communities, and they're of the same view. Everyone wants the healthcare system to be safe and equitable for everybody. And there shouldn't be this additional concern placed on patients about where they fit in terms of the political advocacy of the day. Healthcare should be a sacred space.
Dr. Green, can I return to you? Paragraph 68 of your witness statement, you've outlined the healthcare environment that you hope to see. What does that include for your part?
I might read this. So, anti-Semitism within healthcare is not an isolated or episodic concern. It is a systemic challenge affecting professional conduct, workplace culture, patient trust, and the ethical integrity of healthcare. The healthcare environment that I hope to see is one in which clinical settings remain focused on patient care, professionalism, impartiality, and respect. No practitioner feels compelled to conceal their Jewish or Israeli identity. No patient doubts that care will be impartial. No colleague is collectively blamed for the actions of a foreign government. And no minority group is made to feel that it might be treated different to other patients. Achieving that environment requires more than statements of principle. It must clearly identify unacceptable conduct, establish and consistently enforce professional standards, provide robust, fair and accessible complaints processes, monitor compliance, and impose meaningful consequences where those standards are breached. This must be supported by education, clear professional boundaries, and leadership that treats anti-Semitism as seriously as other forms of racism and identity-based discrimination. And the last point is, I think a better future is possible. Protecting Jewish healthcare workers and patients from anti-Semitism will also preserve the trust on which healthcare depends, uphold the ethical integrity of medicine, and contribute to the social cohesion that this Royal Commission was established to strengthen.
Thank you. And Dr. Green, to take up with you the topic of education and a better future being possible, you've shared in your witness statement, this is at paragraph 61 and 62, a particular situation where you saw the impacts of education firsthand with a medical colleague. Are you able to share what happened?
Yeah, so I was personally involved in dealing with a medical colleague that had infringed and referenced the Holocaust in relation to Israel's treatment in Gaza. And a complaint was made to their college. And they agreed to have antisemitism education, a Holocaust education, and I'm a trained guide, volunteer guide at the Holocaust Museum. I actually personally took them myself. So it was a very personal experience, so I took them on a tour of the museum and I explained why references to the Holocaust are offensive and triggering to the Jewish community, and that individual obtained a greater appreciation of the context and understood that I was not trying to influence their political views, but rather to inform them of their cultural sensitivity. And that interaction gave me the impression that this was a concerned, ethical individual. And they just had a lack of understanding of the impact, the words that they'd used, of the words that they used, and they were unlikely to repeat it.
Thank you. Commissioner, I have no further questions.
Just before I excuse the two of you, Dr. Gordon, you regularly perform procedures in public hospitals, is that right?
Private hospital.
Ah.
Yep.
Well, I'll try anyway.
Okay.
Yesterday we heard from Rabbi Castell, who is the chaplain, the Jewish chaplain to public hospitals, and Rabbi Castell expressed his view that patients are in fact safe in New South Wales hospitals, and I was wondering whether you could offer us any reassurance on that score, but perhaps your practice is outside.
Well, I do. I mean, I speak regularly with colleagues who are at public hospital, and I get questions, is it safe? And I always try and reassure people that I think it is. Yep.
None of that is to, as it were, undermine your evidence about the need for medical practitioners in public hospitals not to display advocacy for any political cause.
Thank you.
Yes. All right. Thank you. Anything arising?
No, thank you, Commissioner.
I'll excuse you both and thank you for your evidence. Yes, Ms. Phillips.
Commissioner, we have a double act this morning.
Another double act.
Our next two witnesses will be Lawson, Broad and Ben Bolot, and the reason that they will be giving evidence concurrently is that they will be respectively speaking to two parts of an organisational submission to the Royal
Yes,
Commission.
very well. Thank you.
Please come forward.
Do you swear by Almighty God that the evidence you give will be the truth, the whole truth, and nothing but the truth?
Thank you, gentlemen. Do sit down.
Mr. Broad, can I ask you to state your name?
Lawson Broad.
And your address is known to the Royal Commission?
It is.
You're the Chief Executive Officer of JewishCare New South Wales?
I am.
And you've prepared a statement that's dated the 27th of July 2026.
I have.
Is that statement true and correct to the best of your knowledge and belief?
Yes, it is.
Commissioner, I tender that statement together with its annexure LB1, which is the JewishCare New South Wales submission. They respectively have a doc ID stat.899.0001.0579 and sub.5000.0001.3621.
Yes, the statement and the annexure will both be received as the one exhibit.
And Mr. Bolot, can you please state your name?
Benjamin Michael Bolot.
And your address is also known to the Royal Commission.
It is.
You are the President of JewishCare of New South Wales.
That's correct.
You've also prepared a witness statement that's dated the 26th of July 2026.
Yes.
The contents of your statement true and correct to the best of your knowledge and belief.
Yes.
Commissioner, I tender that statement, which has doc ID stat.899.0001.0580.
Yes, the statement of Mr. Bolot will be received.
Mr. Bolot, I might commence with you. Is it the case that each of yourself and Mr. Broad had input into the submission that was lodged on behalf of JewishCare New South Wales?
Yes, we did.
And the submission's been prepared in two parts, broadly. The first part covering the client experience of the organisation.
Yes.
And that's a matter that you had primary involvement with and can speak to this
Yes.
morning. And to your understanding, Mr. Broad had primary input into the second part of the submission dealing with the operations of the organisation, and he's better placed to speak to those matters
Yes,
today.
that's right.
Thank you. Mr. Bolot, can I start by asking you about JewishCare organisationally? Is it right that the organisation has been a major service provider for vulnerable members of the Jewish community for over 90 years?
Yes, that's correct.
And the organisation was initially founded to provide services to Jews fleeing antisemitism in Europe who had settled in Australia.
Yes.
Is it right that the organisation's primary services exist across the aged care sector, mental health and wellbeing, disability services, as well as family and child support services?
Yes, that's correct.
And the organisation is a not-for-profit organisation that's also a registered National Disability Insurance Scheme service and support provider.
Yes.
You became the president of JewishCare New South Wales in November of 2025, is that right?
Correct.
But before that, you'd been a director of the organisation from about 2018.
Yes.
Given that long-standing involvement, is it right that you're in a position to give a perspective as to changes in the organisation over the last 7 years or so?
Yes, I can.
Now, can I take you to paragraph 6 of your witness statement? Prior to 7th of October of 2023, approximately how many members of the Jewish community in New South Wales did JewishCare provide support for across its various service segments?
So prior to October 7, it was around 1,200 members of the community on an ongoing basis. Of those, about 450 aged care clients, and a very specific cohort of 283 Holocaust survivors who we provide ongoing support for.
And can you tell me about any shifts or changes in the numbers of people accessing JewishCare services after that date?
Yeah, look, absolutely. The change in the organisation has been quite profound. Certainly from October 7, we saw an increase in people seeking support for mental health, stress-related type disorders or need. Obviously, post 14 December, that changed even more significantly. And I know you heard from Rabbi Castow yesterday. We work very closely with Jewish House, but JewishCare was responsible for the immediate emergency triage. And in that space, we took over 1,000 calls within about a month and a half, immediately after post Bondi. We have arranged over or close to 200 psychological first aid sessions. We have taken on more staff in order to support that significant increase in services. And none of those things we offered prior to the Bondi attack. We had been focusing on mental health prior to the Bondi because of the impacts of October 7, but that's sort of how we had moved from there. We're now currently supporting 39 family members of people who are either killed or were at Bondi, and we have assisted more than 90 people with victim support applications through the different support mechanisms.
And when you referred in that answer to receiving over 1,000 calls, are you able to describe the kinds of services or information that JewishCare is in a position to provide those callers?
So that was the triage line, the emergency line. Some of the services JewishCare can't provide, and in some respects it's easier to talk about the things that we don't provide because we sort of fill the gap for where other organisations in the community can't provide them. So we don't provide food, for example, or emergency accommodation, or first aid or medical care. Essentially, everything else, we will find a way to provide services for clients. And JewishCare has always been there to support the vulnerable people in our community. And what we try to do is make sure that we are able to direct them where they might find services if we don't provide those services ourselves. So that 1,000 people, there will be some who needed immediate assistance. Some may have called to say, where is my loved one? It was very difficult to get information, as I'm sure you've heard, about where people were post-Bondi. And we would try and connect people in that way. But the vast majority of the work we now do as a result of this has been trauma support, first aid, mental first aid rather, and those types of activities.
Thank you. And in your witness statement, this is from paragraph 9, you've described a survey that was administered to JewishCare's clients and staff, the results of which were collected in the organisation's submission to the Royal Commission. Are you able to indicate at a high level how that survey was undertaken and the type of information that it sought to elicit from the survey respondents?
Certainly. I think just as context, JewishCare's clients are largely people who are vulnerable and may not be able to speak for themselves. So we took a view as board and management of JewishCare that it was up to us to go and ask people quite directly what their experiences were, and for us to then be able to represent those to you. And whilst the stories may not be incredibly polished, they do tell a story of the people that we have spoken to. So we conducted structured surveys with a number of staff, including the management team, including Mr. Broad. We then ran very specific sessions with social workers, some of which were facilitated and some of which were just one-on-one conversations. And we had the board appointed an individual from the board who was a communications expert to run that for us. And then we also did a survey directly to clients, which was either face-to-face conversations, typically through their social worker, as opposed to an uninformed person. They needed to be treated obviously very carefully, some of those people. Or we also provided people an opportunity to send us written statements if they wish to do so.
And would I be able to take you to page 10 of the JewishCare submission, and perhaps ask you to share a couple of the survey accounts or responses, first from the social worker and then second from the aged care client, that are extracted in the pink boxes at the bottom of that page.
Sure. So one of the JewishCare social workers' direct statement, this is a quote from them, was, "We're not even dead yet. How can this be happening again?"
And she's reporting that that's something that one of her clients have
Yes,
said
a Holocaust
to her in a
survivor made that statement to her. And that, as you will see in the rest of the submission, that is not an uncommon feeling from Holocaust survivors. The other statement was from an aged care client and a Holocaust survivor. It said, "Ever since Bondi, I haven't gone out unless I have to. I am worried and fearful of being attacked. I am heartbroken. After surviving the Holocaust in Hungary, this beautiful country which was safe for us Jews and non-Jews is not safe anymore."
I might come to you, Mr. Broad, at this point, noting those accounts that have just been identified. The submission goes on to identify some behavioural changes amongst JewishCare clients and then how that impacts upon the organisation's operations more generally. Are you able to comment on having observed any of those organisational behavioural changes amongst clients?
Sure. So I think there is a general hesitancy to go out in public, or certainly a much higher level of vigilance if people do have to go out in public. So some specific examples are when clients are attending a specific Jewish event and they need to catch transport, generally an Uber, to get there, they'll give a false address, an address nearby in a street nearby, to avoid giving a direct location. I had one of our aged care clients call me to express concern that the cab charge cards that they are issued label JewishCare on them, and that's causing people concern and fear when they have to use that card, just because it identifies them as a Jewish person or identifies them as being attached to a Jewish organisation. And I think general engagement with public institutions has been challenged. People have expressed concern about their experience, but I think also our aged care clients and other vulnerable clients are increasingly looking to us to have someone accompany them when they're meeting with a public service, whether that's over the phone or in person. That says to me that they are fearful and concerned about the treatment that they might encounter. They've also expressed that they are reluctant to have to tell their story again and again, because that increases the traumatic experience for them.
Mr. Broad, unlike Mr. Bolot, you commenced your position within JewishCare after the 7th of October of 2023, in around December of 2024, is that right?
That's right.
And you've said in your statement that you came to that role after 20 years of experience in executive and leadership positions across the not-for-profit, community services, government and education sectors.
That's right.
What did some of that past experience of yours include?
The most recent experience, I was the CEO of Somerville in the Northern Territory, the largest local disability service provider in the Northern Territory. I spent a few years in politics. I spent some time in senior roles in the Northern Territory Public Service. I worked for another large not-for-profit, and I also served on several national boards, including Uniting Care Australia, National Disability Services, and I was the president of NT Shelter.
And you've described in your witness statement, this is at paragraph 15, having joined your position within JewishCare having had no prior connection to the Jewish community.
That's right. So I moved from Darwin to Sydney and really had no experience with the Jewish community, certainly not the Jewish community of Sydney.
And you also said that prior to joining the organisation, you also had no prior experience personally in any event of anti-Semitism.
That's correct.
What was memorable about your first week in your role at JewishCare?
So I came into the role having a peripheral knowledge of a difficult environment for Jewish Australians. However, in my first week in the role, there was a car that was firebombed in line of sight of the office. including a bunch of anti-Semitic graffiti, and that obviously caused significant concern across the organisation. People were concerned for their personal safety. They were concerned about coming to the office. They were concerned about the security provisions that JewishCare had in place and whether they were sufficient. They were concerned about being visible through office windows, and concerned about could they be shot.
Can I take you to paragraph 8 of your witness statement? You've said there that though you only joined the organisation in late 2024, you've been made aware that the increase in demand on JewishCare's services due to the rise in anti-Semitism since the 7th of October 2023 has been material. And you've identified what you see as being 3 drivers for the increased demand that you describe. What are those drivers as you understand them?
Sure. So my understanding is that prior to the 7th of October 2023, anti-Semitism really didn't have much of a profile in the organisation. However, following that event, I understand that there was a significant rise in people experiencing anti-Semitism and presenting to the organisation looking for assistance with how to deal with it. So that included families unsure as to how to talk about this with their children. That included our clients who felt increasingly unsafe, and for a time we had essentially a dedicated hotline for people who were able to call, share their concerns and receive assistance.
And you've referred, this is in the first subparagraph of paragraph 8 of your statement, to an immediate increase in need that you've identified post-Bondi. What are the main drivers of that need?
It wasn't just an increase in need, it was a massive increase in need. So following the Bondi shooting, we had people in great distress and in a variety of different forms of distress. People had immediate needs in terms of accommodation. People were stranded and had immediate needs for personal travel or travel for their families. People had difficulty knowing how to locate loved ones, and were just turning to anyone to help them through that process. I think the most prominent need that we're seeing is an increase in people requiring mental health supports. So since the event, we have either funded or delivered over 650 individual counselling sessions. We're seeing people present, whole families present, that have never encountered these sorts of needs before, don't know how to respond to them either as individuals or as families, and are really looking for help to navigate that service environment or to access those services. But importantly, I think people are not comfortable accessing those services that they're aware of, mainstream providers. They want to come to somewhere that they feel safe.
And you've noted not only the volume of the additional demand, but also additional complexity in the work itself. Are you able to articulate some of the particular drivers of that complexity as you've referred to it?
Sure. There are layers and layers to it, obviously. But I think one of our chief challenges has been that our staff, the people providing support to community members, are themselves experiencing direct trauma as a result of what's happened. So finding ways to support those staff while they're supporting community has been a significant challenge. I think people who are presenting are often presenting in a confused state, not being able to themselves necessarily believe what's happening to them or to their families. So it's not simply a matter of someone turning up with an identified need and looking to have that need met. It's people turning up who are experiencing a completely confusing set of circumstances, and our own staff being challenged by having to walk people through that.
Can I take you to paragraph 17 of your witness statement? Mr. Broad, you comment there on what you've described as the particular cost to Jewish staff, and then you go on at paragraph 19 to refer to the load that non-Jewish staff carry. Can I ask you to expand on the experiences as you've observed it, both from the perspective of the Jewish staff and the non-Jewish staff of the organisation?
Sure. Where to start? I think that as a general rule, people have felt less safe. And what that has looked like is people taking measures to reduce their visibility either as a Jewish person or someone who works for a Jewish organisation. So that has meant things like changing our lanyards and removing JewishCare from those. Removing either JewishCare or anything that identifies or associates someone with a Jewish organisation from the tote bags that we give out or uniforms. I think I've heard direct reference again and again to people who avoid talking about where they're employed, changing LinkedIn profiles. And I think that's not just for existing staff. I think when recruiting new staff, it is very confronting to turn up to a charity, a not-for-profit, and encounter a permanent security presence at the front door. We find that we need to be not so much asking direct questions, but being plain in our interview processes, that we are a Jewish organisation through and through, that if people have views or positions that are likely to put them into conflict with the organisation or with Jews more generally, then they should consider that carefully. I think we have had to be very careful about the staff supports that we provide to ensure that they will be safe and sensitive for Jewish staff. So that's things like accessing an EAP service. We want to know that someone who's in that vulnerable position is able to speak to someone at the other end of the line, and have that person be receptive and non-judgmental.
And Mr. Broad, at paragraph 20 of your statement, you said that you did not anticipate how operational security would become a significant part of your role as CEO of an organisation that was focused on disability, aged care and social services. Are you able to comment on what that operational security component looks like in terms of your day-to-day work, and also how it might impact on the other work that you're required to perform as CEO?
Sure. So as I mentioned at the start, I have a long work history in this sector or related sectors, and have never encountered anything like the challenges that I currently experience in this role. I think that filters through to a lot of day-to-day activity, whether that is planning around additional security. So for us, that has meant closing off all entry and exit points to our main building, having a permanent security presence at the building, budgeting around that because they're all extraordinary costs, finding ways to give people assurance of their personal safety at the same time as running security drills or cancelling events because of safety concerns. I think it is and every time there was a car bombing, every time there was graffiti, every time there was a flare-up, we were providing individual supports and group supports for people who felt increasingly vulnerable. I would say that it's a constant topic of conversation within the senior management team. It's a constant topic of conversation through my board reporting and discussions at a board level, and it means real and practical measures around looking at how do we explain anti-Semitism, how do we explain the impact of it, how do we reduce that impact. And I just can't even conceive of facing similar challenges in a similar organisation.
Mr. Bolot, can I return to you? You've said in paragraph 24 of your statement this: while catastrophic for all Jews, the vulnerable have always been disproportionately impacted by anti-Semitism. I want to say that the very stereotypes that paint Jews as wealthy, powerful and invulnerable make it harder for the truly vulnerable. Are you able to expand on that and comment in particular on the insights that you've gleaned over your years with the organisation into what vulnerability looks like in the context of the Jewish community in New South Wales?
Sure. Look, this is quite a complex thought process that's gone into this particular paragraph, because it is, when you really get to the heart of the issues for JewishCare. JewishCare was set up to deal with the most vulnerable people, or to provide support for, rather, the most vulnerable people in our community, people who are disadvantaged through economics, through disability, some people living in social housing. We provide support for people who are incarcerated or their families. The Jewish community, like all communities, has advantage and disadvantage. And unfortunately, anti-Semitism, the anti-Semitic tropes in particular, paint all Jews as being an advantaged community. So JewishCare, when you look at what we try to do, we support people with vulnerability who happen to be Jewish. And those people are now starting to say, I am vulnerable, but the organisations that support me don't see me as vulnerable because I'm Jewish. And that's quite a complex, it's complex for us to deal with. It's firstly complex for us to understand, to get to that point of the anti-Semitism leading people to feel that they can't go and ask for support because they're seen as advantaged, even when they're not. And so that's been quite a difficult transition for us. I think we've sort of got our finger on that now. We know that that is an underlying issue. What we are seeing, which is a very significant change for us as an organisation, is that we were formed to deal with vulnerable people, to provide support for people who were vulnerable for a variety of reasons, not because they were Jewish, but for those other reasons. And now we're providing support for people who are vulnerable because they are Jewish, not because of those other reasons. They just happen to have those other vulnerabilities as well. And so the complexity of what that means for us has been quite profound.
And Mr. Bolot, lastly, I want to ask you about the recommendation that you've advanced in your statement and that's reflected in the organisation's submission. At paragraph 19 of your statement, you've said, anti-Semitism is a distinct trauma context. Victims of anti-Semitism should not be required to educate the systems they turn to for support. Noting those remarks, what's the recommendation or perhaps group of recommendations that have been proposed on behalf of JewishCare?
There's a couple that we have quite specific. I mean, we have not looked at general recommendations in relation to anti-Semitism. We've been looking very much through the prism of our set of clients and their needs. We think that anti-Semitism needs to be recognised as a distinct trauma category within the agencies, particularly that our clients deal with. There are other categories that are specifically dealt with, but because of where we've got to in society at the moment, anti-Semitism needs to be recognised as a category that people, as distinct from general hate in society, none of which we should have, but as a distinct category, so that the victims in particular are not required to restate or be re-traumatised every time they tell their story. And we've seen that happen over and over again, where clients have gone to talk to an agency, whether it's state government or federal government or the healthcare system, and had to restate why they're traumatised as a result of the Bondi event. Doing it once, obviously there is a need to make sure that the right people are getting the right care, but to keep repeating that and to not have it recognised as a fundamental category of trauma, we think needs to be established. And we also think there needs to be a single point of recognition for victims of very specific events like the Bondi event, which is quite different from other events that occur, in that there is quite a defined group of people who are specifically and directly affected by it. For those people to have to come back to the system over and over again, and we have instances of where the same government agency has asked the same people to re-explain why they're a victim of Bondi. We think there should be some mechanism to recognise those people early and once, and for that information to be available to agencies so that the individuals are not re-traumatised by simply having to tell their story again.
Thank you, Commissioner. I've got no further question for these ones.
Just one question for you, Mr. Broad. You say in your statement that before joining JewishCare you had no association with the Jewish community. Am I right to infer you are not Jewish?
That's right.
Yes. Since joining JewishCare, have you experienced acquaintances or friends being somewhat distant to you, or any change in their attitude to you because of your employment?
I'm hesitant to talk about my own experience because I'm not Jewish.
Yes.
But I think some have trouble even talking about it. Some want to avoid the conversation about where I work because inevitably it turns into a political conversation. I think when I talk about where I work, there are at times sort of downcast eyes. People want to avoid that, and people are far more interested in talking about politics associated with a conflict in the Middle East than the vulnerability of the clients we serve.
And do I take it when you were working in the Northern Territory, people weren't particularly interested in your views on the politics of the Middle East?
Just never came up.
Yes. I take it nothing arising out of that. Thank you both, gentlemen. You're both excused. Convenient time for morning tea, Ms. Phillips?
Yes, thank you, Commissioner.
Yes. I'll adjourn for 15 minutes. Yes, Ms Phillips.
Commissioner, the next witness will be Dr. Zhaoli Dai.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say, I do.
I do.
Can you state your name?
Zhaoli Dai.
And your address is known to the Royal Commission. You've prepared a witness statement dated the 24th of July 2026.
That's correct.
Is that statement true and correct to the best of your knowledge and belief?
Yes.
And is it right that the statement annexes a submission that you and a co-author prepared for the Royal Commission?
Yes.
Commissioner, I tender the statement and the accompanying submission, which is Exhibit DZ1. The statement has doc ID stat.899.0108.0001 and the attachment has doc ID stat.899.0108.0004.
Yes. The statement and the accompanying annexure will be admitted as an exhibit.
You are an honorary senior lecturer at the University of Sydney, affiliated with the School of Pharmacy and the Charles Perkins Centre, is that right?
That's correct.
And your background is in health services research and as a population health epidemiologist.
Correct.
Your research over a number of years has particularly focused on healthcare policies and patient-centred outcomes.
That's correct.
And that includes publications examining how healthcare environments, social and cultural factors influence patient experience, health outcomes and healthcare quality.
Correct.
You've published on various topics related to patient experiences in healthcare settings. Can you identify some of the areas of those publications that you've delivered in the past?
Yeah, so I work with the PHNs in New South Wales and Victoria since 2020 until 2021, and that's really to understand virtual care utilization during the COVID-19 pandemic. And since 2022, I also collaborate with the Bureau of Health Information in New South Wales Health and publish series of studies to understand patient experience in public hospitals in New South Wales, specifically looking at their experience in hospital food service, pain management, medications, as well as their interaction with clinicians, and to understand how these different areas impact their recovery outcomes. And they were published in several peer-reviewed international journals.
And the submission that you have prepared to the Royal Commission seeks to draw on some of your experience in looking into issues concerning patient experiences in healthcare settings and patient outcomes, is that right?
That's correct.
And that's particularly in relation to experiences of anti-Semitism?
Correct.
And you prepared your submission together with another professor, and that co-author's academic background is in governance and the role of culture within organisations.
That's correct.
And in terms of your contribution to that submission, that drew on your health services and epidemiological background.
That's correct.
Now, can I take you to paragraph 6 of your witness statement? You've referred there to leading an effort in a systematic literature review and evidence synthesis for the purposes of preparing the submission that you provided to the Royal Commission. Is that right?
That's correct.
Was the purpose for conducting that literature review, and this is taking you to paragraph 5 of your witness statement, to use that as a base from which to consider anti-Semitism as a social determinant in connection with the healthcare system and policy frameworks.
That's correct.
Can I take you to the submission, please, which is the annexure to your statement? Your submission, if you turn to page 2, addresses 2 ways in which anti-Semitism may operate in healthcare settings. The first way that you've identified is for Jewish patients, is that correct?
Correct.
And the second way that you've identified anti-Semitism as operating is for Jewish healthcare professionals, is that correct?
Yes.
I take you to the second paragraph on page 2. You've described there how you see anti-Semitism operating for patients in the healthcare system on the basis of the literature review and other examination that you've conducted. Can you explain how you see anti-Semitism emerge and manifest for patients?
So, looking at the reports and anti-Semitism acts and events since October 7th, with that lens, I looked at how anti-Semitism impacted patients in the healthcare system in a way that how anti-Semitism impacted patient safety, perceived safety, the fear, and also their mental well-being, and how these further impact healthcare management for patients who seek care. And that's based on the increased anti-Semitism literature published in several countries, including Australia, the US, the UK, and Canada.
I'll come to some of that literature in a moment. Just at a high level, the impact that you've described on page 2 in the second paragraph for healthcare professionals, what were some themes that you identified affecting those professionals?
So in the healthcare professional target group, we also see that anti-Semitism operates within the professional and organizational context, that healthcare professionals, they were afraid to identify as Jewish, and they also may encounter patients whose attitude that are influenced by prejudice and misinformation, and these kind of prejudice were also seen from colleagues and in the institutional environments in which anti-Semitism is insufficiently recognized. So these are some of the findings from our review targeting at the healthcare professionals.
Thank you. I want to ask you next about the way in which you conducted the literature review that you've described. Can I take you to page 6 of your submission? I understand that what you were seeking to look for in that review work was studies that examined anti-Semitism or anti-Jewish discrimination in relation to psychological safety, mental health, and healthcare access from Australia, the United States, and the United Kingdom and Canada. Is that right in terms of the resources that you were looking for as part of that review?
That's correct.
And can you explain how you went about trying to search for those sorts of resources?
Yeah, so to conduct the reviews, both of them, and for this one, we follow very, very closely to the Cochrane Systematic Review Guidelines, which is an established gold standard for systematic review of in terms of that kind of research. And we first identified the research questions, which is that because of the increased anti-Semitism since October 7, we want to understand what is the impact of anti-Semitism on perceived safety and fear of victimization in patients, and what is the impact on mental health among Jewish individuals, and then also what are the implications of anti-Semitism for healthcare access, trust, and engagement. And with that, so we, based on the research questions, and we use keyword search, looking at Jewish patients, Jewish individuals, the mental well-being, patient safety, as well as healthcare engagement. We look into 3 databases, which is Medline, Scopus, and ProQuest Central, to identify relevant literature between 2015 to February 2026. And we have a set predefined eligibility to identify the studies, and then these studies were included, such as the quantitative studies, qualitative studies, mixed methods studies, and review studies that concerned anti-Semitism or anti-Jewish discrimination in relation to what I talked about earlier, the outcomes, which is the psychological safety, mental health, and healthcare access and engagement outcomes, and limited to the countries that we just described earlier. So this is how the research literature were identified. And after we identified 12 studies, and we also conducted study quality assessment to understand how these studies were qualified in terms of their methodological quality.
Thank you. And ultimately, can you comment on the set that you developed of surveys, research articles, other papers that contributed to your overall analysis? Are they the resources that you've listed in the annexures to the submission?
So in the submission, you can also see there's a table attached in the appendix, and so we included 12 studies. So there are 4 studies from Australia, including a large survey among Australian Jewish adults that includes over 7,000 adults, published in 2024 by Bankier, Karp, and Graham. Another 3 other studies that includes and were drawn from Australian participants are the Teshuva 2017, Austin 2025, and Kreis 2024. So these are the 4 studies from Australia, and then we have 3 studies from Canada. Some of them are qualitative interviews, and some of them are cross-sectional surveys, and that included 2 of them. And then we have the rest of the studies from the US, and then 1 study from the UK, which is part of the review in the publication by Zhaoli 2023.
Thank you. And is it right that a number of the studies that you've mentioned have a specific focus on the healthcare sector, but some of them examine more broadly anti-Semitism in different organisational settings?
That's correct. So only 3 studies are directly in the healthcare setting, and even those 3 studies that are directly in the healthcare setting are between Jewish Holocaust survivors or descendants of survivors interacting with healthcare providers, and the other study was conducted in Canada, and these were Jewish individuals and also directly interacted with their healthcare providers. And the rest of the studies, they are more in the preclinical kind of or community, that kind of setting to understand how anti-Semitism impacts patient safety and psychological well-being.
One publication or survey report that you've referred to in your submission is, I think it's been made available to you and the Commissioner, just to give an example of some of the material that you looked at. It's titled Antisemitism in American Healthcare, a survey study of reported experiences. And it's the authors are Michelson et al., published on the 11th of December 2024. Can you just identify the results of that survey and what you understood that it sought to identify from the perspective of anti-Semitism in American healthcare?
Yeah, so that the study is particularly targeting at healthcare professionals in the United States, and I think that is a survey around 625 that's in the survey, and in this survey, what it reports is that around these 645 Jewish healthcare professionals, 30% of them, of the 2,100 healthcare professional provided that kind of surveys. And it's quite striking in terms of 74% of them reported that their organization require anti-bias training. However, only 2% of these healthcare professionals noted that the anti-bias training in the organization includes anti-Semitism training. And that's one finding. And the other one is also very important to know is that 72% of these respondents agree that anti-Semitism should be included in anti-bias training. The other thing that I would also like to draw on your attention is that 14% of these healthcare professionals also experience anti-Semitism from patients that they treated, and 30% of the of these respondents experience anti-Semitism by their medical colleagues.
And this is, as you've said, a United States study of Jewish healthcare professionals. Are you aware of any study that was done at similar scale of Jewish healthcare professionals in Australia in the last 2 years?
Yeah, not in my knowledge. Basically, in our review, we did not identify any healthcare professional surveys or interviews in our review, and so it's quite limited in the Australia setting.
And can I take you to page 7 of your submission? In the second paragraph, after describing the papers that you identified from your searches, you've made some observations there about what you drew from the convergence of the various literature resources that you reviewed, and you said that the literature converged around several recurring issues. What were the issues that you'd identified from that review?
Yeah, so across the literatures among Jewish healthcare professionals, We identified 4 issues. The first one is there was a hostile and exclusionary workplace and organizational climates encountered by Jewish healthcare professionals. The second one is that Jewish healthcare professionals, they had issues around revealing their identity, and in studies they also reported they often self-silenced and have belongings issues with their organizations. And the third issue is that there were tensions within therapeutic, collegial, and client-facing interactions following their experiences of stigma, polarization, or trauma. And the last, which is the fourth issue that we identify, was that they also found there was a failure of institutional recognition, particularly within the framework of diversity, equity, and inclusion, as well as the anti-oppressive practice frameworks.
Thank you. And if I can take you to page 9 of the submission, you made reference before to the experience of patients and particularly the concept of perceived safety. I think you've included a definition of perceived safety in the second full paragraph on that page. Can you explain what you understand by perceived safety amongst a Jewish patient cohort?
Yes, so perceived safety was defined as feeling respected, free from discrimination or victimization, and able to access care without fear. And even though it is a perception, however, it is increasingly recognized as a key determinant of healthcare utilization, adherence, and patient-provider interactions. And in fact, in patient surveys conducted in New South Wales and Victoria, patient perceived safety is frequently monitored and surveyed from year to year.
And can I take you to the bottom of page 10 of your submission in the last paragraph? You said the extent to which these dynamics shape the clinical environments has not yet been fully established by direct empirical evidence. Are you referring there to the dynamics both for healthcare professionals and the dynamics for patients there, not having yet been fully established by empirical evidence?
I think there are several reasons to make this statement. Number one, as I mentioned earlier, there's very limited studies to understand how antisemitism impacts patients as well as impacts in healthcare professionals. And I think that kind of limited evidence limits our understanding regarding how the clinical environment can really fully be understood to provide that more direct empirical evidence.
And I think one suggestion that you have in that part of your submission is that with further research, more information can be known and more data can be gathered as to potential recommendations to respond to issues. Is that right?
That's correct.
Now, from the data that you were able to collate from the literature review that you've described, I think that you have articulated 5 system-level issues that you've seen as operating in relation to anti-Semitism in healthcare settings. Is that right?
That's correct.
And in relation to each of those issues that you've identified, you've gone on to provide, at least at a high level, some recommendations as to how they can be addressed. Is that right?
Yes.
I might take you in turn to each of those issues as you've referred to them, and then the recommendations or the improvements that you've identified as being possible for those issues. Can I take you to page 2 of the submission in the executive summary? It might be a convenient place to take this up with you. At the bottom of the page, of page 2, first, can you identify what the first issue is that you've identified from the literature review you've described?
Yeah, as mentioned earlier, I think really the first issue we identify from both of the reviews is that there's a gap in measurement and evidence within healthcare settings among patients as well as professionals. Although there is substantial evidence exists on anti-Semitism in the broader social context, the level for patient and also the level for healthcare professionals within the healthcare system is particularly limited, and that's not just in other countries, but also in Australia. It's the same issue, and anti-Semitism is not routinely measured in patient experience or quality of care frameworks. So that creates a structural blind spot, limiting healthcare systems' capacity to identify risks, monitor changes, and implement targeted interventions.
And is it right, and this is over on page 3, at item number 1, that the recommendation that you would propose to address that measurement gap is to effectively have better systems in place to gather that sort of data and information?
Yep.
Can I take you then to the second issue, which you've addressed at the top of page 3? What's that structural or systemic issue as you've identified it?
Yeah, so the second issue is about anti-Semitism contribute to patient vulnerability before they access clinical interactions. That experience of discrimination, perceived threats, and reduced safety shapes patients' mental health and expectations of care. And these conditions influence whether individuals seek care, disclose relevant information, and engage with healthcare providers, which create risks for patients to seek care, and they may delay the care. Utilization of care may be reduced, and the communication with clinicians may be impaired because of that.
And the recommendation I think you've proposed for that issue of patient vulnerability, this is over at the top of page 4, is that healthcare organisations should try and strengthen culturally safe environments that try to reduce fears, support identity disclosure, and enhance trust. Is that right?
That's correct.
The Commission received some evidence yesterday from Rabbi Castell talking about initiatives like creating kosher food, for example, in cupboards in hospitals in New South Wales. Would that be an example of a kind of measure to support or strengthen a culturally safe environment?
Yeah, definitely. I think some of the mechanisms like this to display and display, Jewish cultural symbols and provide, cultural food to patients definitely will change that kind of environment and make patients feel more inclusive, safe, and belong to the institution.
And in giving that answer, are you drawing on some of your own professional experience examining the role of nutrition, in particular in healthcare settings?
Particularly in that kind of Jewish cultural food aspect?
More generally?
Yes, I do look into cultural food and how does that improve patients' satisfaction with care and also recovery outcomes, so definitely.
And if I can take you to the third issue you've identified on page 3, you describe a failure of recognition within clinical practice, and that anti-Semitism is often insufficiently incorporated into diversity, equity and inclusion frameworks and healthcare training. Can I ask you about the recommendation that you offer to address that failure of recognition as you've described it?
Yes, I think for the recognition, it goes a few levels, and I think recognition, number one, require healthcare professionals and trainees to receive target education on anti-Semitism and to understand cultural safety and understand how to deliver trauma-informed care to Jewish patients, particularly those who are survivors or descendants of survivors. And that kind of training also should be included in the anti-bias framework. The training about anti-Semitism should be within in the anti-bias framework, so that healthcare professionals will be equipped to and understand how to treat patients in a culturally safe manner. So that's one of the recommendations that we provided to address the failure of recognition within clinical practice.
And then the fourth system level issue that you've identified as one that can arise in healthcare settings is that clinical interactions might be distorted by prejudice or by misinformation. And I understand that the issue that you're identifying there might include, on the one hand, overt prejudice, is that right?
Yes.
And that it might also include more subtle forms of unconscious bias, if I can put it that way. Is that right?
That's correct.
And are you able to explain what one of those overt prejudices might look like in a health setting on the one hand, and what a more subtle or unconscious bias might look like on the other, and then the measures that you think ought to be implemented to address each of those?
Yes, I think like more overt type of prejudice would be just call their name Jews, I don't want to, say those really very adversary, the kind of wording. Subtle kind of prejudice could be have political imagery displayed in the healthcare setting that make Jewish patients feel unsafe and fearful, and on the other hand, this kind of imagery display can, from healthcare professionals, can also impact Jewish healthcare professionals and make them feel unsafe and fearful in the workplace. So these are the examples of subtle prejudice and biases or discrimination that make Jewish individuals and healthcare professionals do not feel safe and confident in the workplace and or the healthcare setting. And to address these, again, education is very, very important. However, I think setting up the norms, policies, standards at healthcare workplace and organizations are making them very clear, and that should be very important to be known to the healthcare professionals.
And just picking up in what you've said on page 3, I understand that your concern in relation to this issue is that these dynamics that you've been describing can affect trust and the quality of clinical interaction, and that's even in the absence of overt discrimination. Is that right?
Yes.
And then finally, you've identified as your 5th point the issue of education, both within medical training organisations, I think, and workplace environments more broadly. Again, what's the issue or the inadequacy that you've identified there, and how do you see improvements being possible in that educational space in healthcare settings?
Yeah, I think the more broadly issues would be in the education system, particularly those in students, medical students or healthcare students in schools or universities, to make sure that training about anti-Semitism will be recognized, minimized, and normalized, and make sure that these training would be included in their curricula in the education and training programs.
Thank you, Dr. Dye, for your evidence.
Doctor, just one question, dealing with the question of training of healthcare professionals in anti-Semitism because of the particular impact of anti-Semitism on Holocaust survivors. You also referred to descendants of Holocaust survivors. And is there a reason why there is a particular need in terms of the health outcomes for descendants of Holocaust survivors, that they are treated by people who have an understanding of anti-Semitism?
That's correct. And
is there a particular reason for that?
The reason for that is for Holocaust survivors and descendants of Holocaust survivors. They carry the historical trauma with them, and these pass on to the next generations. However, with October 7th attacks, Bondi attack, these more contemporary shocking events as cumulative effects, adding on their historical trauma that make them feel particularly vulnerable in the healthcare setting to seek care.
Yes, thank you, Doctor. Now, is it Miss Kearns? Do you have any re-examination of the doctor?
No.
Yes. Anything arising from...
Just one matter, Commissioner.
Yes.
Dr. Dye, on page 13 of your submission, just taking up the point that the Commissioner has just raised with you, can I take you to the paragraph, it's this first full paragraph on the page that commences importantly. At the end of that paragraph, you have a sentence that says this: emerging evidence shows substantial increases in anxiety, perceived threat, and reduced safety among Jewish populations, with these effects shaped by both contemporary social responses and historical forms of collective trauma. When you were just answering the question that the Commissioner asked you, were you drawing on some of the review of the literature that you have footnoted in that part of your submission?
Yes.
Thank you. Thank you, Dr. Dye. You are excused.
Thank you.
Commissioner, I call Tim Duck.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say, I do.
I do.
Do sit down. Yes.
Please state your full name.
Timothy Duck.
Your address is known to the Royal Commission. You are currently employed by the New South Wales Ministry of Health, but you hold the position of Director of the National Health Secretariat.
That's true.
You've prepared a written statement dated 21 July 2026. Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes.
Commissioner, I tender the statement. It has the ID STA.899.0001.0217.
Yes, the statement will be admitted as an exhibit.
Commissioner, upon the tendering of that statement, it may be a convenient time for me to note there are certain confidentiality claims in respect of Mr. Duck's statement and annexures. Can I indicate the claim is not pressed in respect of paragraphs 27 and 35?
27 and 35?
Correct.
Yes.
Otherwise, Commissioner, I know we received correspondence on Monday from solicitors assisting indicating that particulars of the claim will be articulated in respect of any questions asked of Mr. Duck in relation to the matters the subject of the claim.
Yes.
I rose now, though, noting that it's been tendered, and I understand that there's otherwise would be a general access to the statement. Can I say, aside from claims over personal contact details in some of the annexures, which we say are sound claims on the basis of privacy considerations,
Yes.
the sensitivity underlying the claims is all the same, and that is that the evidence relates to ministerial discussions conducted in committee in circumstances of confidence.
I see.
And so I'm instructed that it's the public release which may prejudice full and frank participation in such discussions.
Yes.
Commissioner, consultation would be necessary with all the health ministers to permit instructions to be given to me, or in fact to Mr. Duck,
Yes.
to change the position, and that has not occurred.
I see.
In those circumstances, if you're minded to uphold the claims, then to the extent they attach to content relevant parts of the statement, Mr. Duck could do so in closed court. If Commissioner, you are not inclined to uphold the claims, then that would be, of course, respected.
Yes. Well, thank you for that, Ms. Callan. I'll firstly seek Mr. Lancaster's submission.
Commissioner, the step of counsel assisting tendering a statement brings it before you in evidence. It does not have any automatic effect of releasing the material to the public.
Yes.
So in accordance with usual procedure, there will be a process undertaken by the solicitors and counsel assisting in relation to the confidentiality claims. I can ask questions that navigate the claims
All right.
which have been made.
Does that satisfy you, Ms. Callan?
Yes.
Yes.
Thank you.
Very well. We'll proceed.
Mr. Duck, the National Health Secretariat is a body that provides governance, coordination and secretariat support to the Health Ministers meeting.
Yes.
the Health Ministers meeting is an interjurisdictional body comprised of the Commonwealth Minister for Health and the Health Ministers of each state and territory, is that right?
That's correct.
Your statement responds to requests for information that the Royal Commission made of the Health Ministers meeting, doesn't it?
That's correct, yep.
Now, can I just understand a little about the operation of the Health Ministers meeting? It convenes 4 times a year, is that right?
It does fluctuate, but it's generally a minimum of 4 times a year.
And it aims to address health issues of national importance, to promote cross-border collaboration and joint decision-making, is that right?
That's correct.
And could you explain in a little more detail the role of the National Health Secretariat, which you direct, how it sits within that organisation, and perhaps in that context also refer to the Health Chief Executives Forum?
Yep, happy to. So the National Health Secretariat is an independent group that is funded by all jurisdictions, so the Commonwealth Government and all states and territory governments all fund my team, and where I guess our service is to provide fair and equal support to all jurisdictions, and that is in regards to coordinating the work across the Health Minister's governance structure, so delegating work within the governance structure, tracking that work and ensuring it's reported back to the Health Chief Executives Forum and the Health Ministers Forum as agreed. We provide direct Secretariat support to Health Ministers meetings, as well as what you just mentioned, the Health Chief Executive Forums. So the Health Chief Executive Forums are the Chief Executives of all health departments across the Commonwealth, states and territories, and they're the heads of those departments, and they meet, and that group officially reports into the Health Ministers meeting, and Health Ministers meeting is one of the many ministerial councils that report directly to National Cabinet.
The Health Ministers meeting would consider from time to time issues of health reform, funding, regulatory reform and the like, is that right?
Yes, that's correct.
And does it have a decision-making role, or does it provide advice to the National Cabinet, or do the ministers habitually act in accordance with what the Health Ministers meeting outcomes?
So it would depend on the topic going to the Health Ministers meeting, so there are certain topics that fall within their portfolios and ability to make decisions, yes.
Now, one particular function of the Health Ministers meeting is conferred by Section 11 of the Health Practitioner Regulation National Law, is that right?
That's correct.
And that section provides a power to issue directions to the Australian Health Practitioner Regulation Agency, or AHPRA?
Yes.
And there's also a power in the Health Ministers meeting to issue directions to health professions that are part of the National Registration and Accreditation Scheme through the national boards of each of the professions.
Yeah. It's probably good for me to state I'm definitely by no means an expert in the national law and how it unfolds, but the policy directive was to AHPRA and the medical boards that are part of the regulation system of the practitioners regulated in Australia.
Yes, so you've, I think, attached to your statement a policy direction that was given in 2025 by the Health Ministers meeting to AHPRA and to each of the national boards, yes, of the professions. Yes. Now, I'll come to that in a moment. Your statement refers to a meeting of the Health Ministers on the 13th of June 2025, and then subsequently a direction was developed and considered by the Health Ministers on the 12th of September 2025.
Yeah.
And that came to be issued on the 28th of September 2025 and that's the direction that you've attached to your statement that is made under Section 11 that requests AHPRA and the national boards to undertake additional work to improve the health practitioner response to racism and discrimination, including anti-Semitism.
Yes, correct.
Now, can I bring up a copy of the direction onto the screen, HMM.001.001.0012, behind tab 6 of your statement for those who have tabs. So the first page of the document is an introductory explanation of the direction, which is on the next page. If you just look at the heading, if you look at the paragraph beginning racism and discrimination, the final sentence in that paragraph is the Health Minister's indicating it's unacceptable for any member of our community to feel unsafe when seeking or providing care in our healthcare system, right?
Yep.
And then there's a reference to, in the next paragraph, to a provision of the national law and an indication that the Health Minister's request a regulatory response to improve public confidence and ensure Australians feel safe when accessing care in our health settings. There's a reference in the next paragraph to the strong example provided by the steps undertaken to address racism experienced by First Nations people in the healthcare system. Can you provide some context to that strategy in terms of an improvement to cultural safety in the context of racism and discrimination?
I'm actually not, I haven't previously been directly involved in that work, so I'd be able to go back and see if I have anything on file. The role of my team is to coordinate the work amongst the experts, so I'd have to go and talk to the people leading that work.
To go over the page then, to look at the content of the policy direction, it's addressed to AHPRA and also to the national boards. Now that's a reference to the 15 boards that govern healthcare related professions.
Yeah. So my lay understanding is for each profession that is regulated under the national law, they have a board associated with them.
And I'll show you the list of the boards in a moment, but just for present purposes, to look at the direction itself, it has two numbered directions. The first is to undertake a review of notifications and complaints processes on racism and discrimination, including anti-Semitism. Right?
Correct.
And the second is to ensure registered health practitioners engage in appropriate education and training to build skills and knowledge that promote a culture of anti-racism and discrimination prevention in the delivery of healthcare services.
Correct.
And there's an indication further down the page that within 6 months, AHPRA and the national boards are to report back with options and whatever proactive steps have been taken.
Correct.
Now, can we draw from this that when the resolution was adopted and the direction given, the consensus of the health ministers around the country was that AHPRA and the national boards needed promptly to undertake additional work to respond to discrimination and racism, in particular anti-Semitism in the healthcare area?
I wouldn't be able to speak on the minister's behalf, but the policy directive was agreed and it was issued.
Now, the second paragraph's reference to appropriate education and training to build skills. Do I take it from your earlier answer about the example provided by the First Nations strategy that you're not in a position to identify a comparison with the education and training provided in that strategy at the present time?
So not to the one that you referred to on page 1. That's not information I'm available that I have available to me.
Right. Is it right to say that by reference to the requirement that AHPRA and the national boards respond within 6 months, that the health ministers can be taken to have been keen that there be a prompt and appropriate time for implementation of the measures to address anti-racism as it's described, and to put in place processes on racism and discrimination, including anti-Semitism?
Sorry, once again, I wouldn't be able to speak on Minister's behalf. I'm aware of the period that was provided to AHPRA for them to respond to the policy directive, but that's all I'm aware of.
Right. Now, the references in the direction to anti-Semitism give rise to an immediate question of what the health ministers mean by anti-Semitism. Was there a specific adoption of a definition of anti-Semitism for the purpose of the direction?
So from my involvement in the health ministers' meetings and the papers that I'm aware of, I'm not aware of a specific definition being used. Now, in terms of your own position as an employee of the New South Wales Ministry of Health, does the New South Wales Health Minister have a particular understanding of anti-Semitism by reference to any particular definition, the AHPRA definition or any other, to your knowledge? Not to my knowledge. I haven't spoken to the New South Wales Minister of Health about the definition of anti-Semitism.
Do you know if AHPRA or the national boards have come back to say anything to the effect of what definition of anti-Semitism should we be applying in application of the policy issued by the health ministers' meeting?
I'm only aware personally from what AHPRA has made public, and that's not necessarily just from my role as the Director of National Health Secretariat. I've seen the joint media release that they've put on their website to say that they've adopted a particular definition, and they'll use that definition to guide their practice.
Yeah. And that understanding is that they've adopted the AHPRA definition and will use
yes.
that?
Apologies, yes.
Now, on the 30th of March, AHPRA provided a quarterly update to the health ministers, which covered its initial response to the direction. Is that right?
So that first one, I believe, was part of their quarterly update. So that's a regular thing that happens regardless of this policy directive. So AHPRA did include a brief update on their progress, but that wasn't their report back, which is the 6-month report back.
Okay. Right. Before I get to the 6-month report that's referred to in the direction, can I take you to that quarterly report, the 30 March 2026 report, as the ID HMM.0001.001.0013. And this is a letter from the AHPRA and the national boards corresponding together on the 30th of March to the health ministers' meeting.
That's correct.
And this may be a convenient place to show you, if you just have a look at the footer right at the bottom of the page. It refers to, which hopefully can be expanded note right at the foot of the page. You can just see those 3 lines down the bottom. Down yet again. Yes, so this seemed to be the most convenient list I could find of the professions covered by the reference to the national boards. Is that right?
Look, I just eyeballing them now. I believe the CEO of AHPRA is providing evidence today, and he'd be better placed than I am to confirm how many national boards sit within the structure.
Yeah, well, judging by their correspondence, it includes that list of, I think there are 15 professions there. Now, going back to the letter itself, this is, as you've indicated, part of the regular quarterly updating process.
Correct.
And in the middle paragraph of the page, AHPRA and the national boards say we're pleased to shine a spotlight on our ongoing work to address racism through building capacity of AHPRA and the national boards to respond to racism and discrimination, including anti-Semitism.
Correct.
And then in the attachment, if we could go to page _0004. The spotlight page indicates down at the foot of the page some information about notifications received regarding racism and discrimination.
Correct.
And notifications is a catch-all word that in other contexts might be described as complaints, but it's when an issue is raised in respect of the conduct of a healthcare professional.
That's my understanding.
Yeah. And so for the period 1 October 2023 to 31 January this year, there were 449 notifications based on claims of racism or discrimination. That's
Correct.
what was reported to you?
That was, yes.
Yeah. And that was 1.6% of all notifications received over that period.
Correct.
And you'll see at the top of the page, AHPRA and the national boards were reporting that in February, that is February 2026, there was a trial of a new education program on anti-Semitism that had been designed by the Australian Centre for Jewish Civilization at Monash University.
Correct.
Have you been, has the Health Ministers meeting or the Secretariat been advised of the details of that education program?
At that stage, what's in that report is all that I'm aware of, and that went to the Health Ministers as part of their update. I believe there is other pieces of work going on which will be covered in the action plan I think you'll be talking about shortly, which was provided at that 6-month mark.
Right, well, I'll take you to that 6-monthly response, which you've attached to your statement. It's dated 13 April. It's HMM.0001.001.004. Now, this document provides the progress report that was required within 6 months in the direction.
That's correct.
Now, the letter which you've attached in full includes a reference to data relating to racism and discrimination, including anti-Semitism, from July 2023 until February this year.
Which document's that, sorry?
So if we go to page _0005.
Yep. Yes, that's correct.
And it sets out the detail of notifications information since July 2023 until 28 February this year.
Correct.
And I'll take another witness through some of the detail of that, but what has occurred since the Secretariat's or the Minister's receipt of that 6 monthly report?
The 6 monthly report back. So that was presented to the ministers at their health ministers meeting in May this year, where ministers noted the 6 monthly report. They had also agreed to task a section within their governance structure. So there's a number of sub-entities within the health minister's governance structure who are experts in different parts of health policy or program. So the sub-entity responsible, or who are the experts in health workforce, they're called the Health Workforce Task Force, were tasked to review this 6 monthly report back and provide their expert advice back to the Health Chief Executive Forum on their review.
And so that has been allocated to the Health Workforce Task Force by the ministers?
That is correct.
And has a time frame been given for their
Yep.
that task force response to the ministers?
So that advice, I've scheduled for it to come to the 14th of August Health Chief Executive meeting.
And at that meeting is the proposal that the health ministers will consider and give a substantive response or take some further action in relation to AHPRA and the national boards?
So at this stage, they're using the process that they've established, which is to consult their experts in health workforce, and they're waiting for that advice to come back. The meeting on the 14th of August is of the Health Chief Executives Forum, so that's the health chief executives that run the each jurisdictional health departments, where they come together and they'll review the advice and update the health ministers meeting based on what that advice.
And is there a scheduled meeting for the ministers themselves to consider the issue, or is that yet to be organised?
So there are remaining scheduled health ministers meetings between now and the end of the year. There'll be 2. At this stage, we're waiting for the advice from the experts to see their thoughts on the 6 monthly report and whether anything else is needed, and that will be first assessed by the Health Chief Executives Forum, and they'll likely determine the right course of action.
Okay. Now, on the 18th of June this year, there was another quarterly update from AHPRA and the national boards.
This is correct.
And you've attached that to your statement. Can I take you to it, please? HMM.001.001.0021. The AHPRA and the national board's correspondence says towards the foot of the first page that we expect to register 1 million health practitioners by the end of 2026.
I can see that.
Yes.
It's not the one that we're highlighting right now, but I can see that is correct.
Yes. And AHPRA and the national boards have said to the ministers' meeting in the next paragraph, our commitment to eliminating racism and discrimination across the health system is absolute. And then there's a reference to some improvements that have been made in handling of notifications and time for disposition of notifications.
Yes, that's correct.
Yep. And AHPRA and the national boards say in the correspondence that the time to investigate and complete these sorts of notifications has dramatically reduced from 132 days in 2024-25 to 54 days this year.
So based on what AHPRA has provided there, that's correct.
Yeah. Now, is it right that what consideration has been given to this document by either the chief executives or the health ministers?
So it's gone directly to the health ministers. There's part of our, I guess, business supports around the Secretariat supports is that business can still continue out of session, and that is sent to each individual minister for their noting or for comment, depending on what the paper is asking of ministers. So this update was for noting. So that's what's happened with that update. It has been it's been issued to health ministers out of session.
So your Secretariat has sent it to all of the health ministers for out of session consideration.
Yes.
You recommended it be noted.
Oh, not me. The paper did. So when AHPRA provides their quarterly update, they are always for noting. Ministers have the option to go to a default of no response, which is taken as noted. They can write back and note it, and they can write back with a note with a comment alongside their note.
Right. And is there any action by any of the ministers of which you're aware responsive to the 18 June update?
So of the responses I've had back, I have no comments no comment on that update.
Okay. Do the Ministers for Health still regard this general topic as a matter that requires prompt attention and resolution?
That would be a question for the members of the Health Ministers meeting.
You in the Secretariat don't know the answer to that question?
I definitely would not be talking on behalf of 9 health ministers.
The health ministers meeting was also asked by the Commission if it had any other recommendations to counteract and prevent manifestations of anti-Semitism or other forms of racism and discrimination within public hospitals or public healthcare settings.
That's correct.
And you've addressed this in your statement by referring to the direction to AHPRA and the national boards that I've taken you to.
So when I received the summons, I answered that question based on what I've witnessed in meetings and what documents I had on file.
Now, AHPRA and the national boards, their area of operation is in respect of the regulation of healthcare practitioners, isn't it?
Of the ones that are registered, yes.
Of the ones that are registered. That AHPRA and the national boards don't themselves have a direct role in regulating, for example, the administration of hospitals or the general experience of patients in hospitals, is that right?
So each jurisdiction, each health minister has the remit of their own jurisdiction, and that's to do with protocols and code of conduct of all employees of their jurisdiction. So I'm employed by New South Wales Health, so I'm bound by the code of conduct, and I'm very aware of it, I guess the stance in the code of conduct around discrimination and racism. So in regards to the practitioners that are regulated by AHPRA and the national law, if they're an employee of that health service, they would have their obligations under that employment as well as their obligations under the national law. Is my understanding, once again, not being an expert in that space.
Is there any process by which the health ministers meeting is informed about the initiatives or activities of the health districts throughout the states and territories, particularly in relation to, for example, education and training and racism and discrimination?
So based on what I'm aware of, at a health ministers meeting, the only items that I can think of is the ones that I've provided in regards to the policy directive around education and training. to AHPRA and the medical boards. But I honestly, I haven't researched everything I have. I'm just going off what I've seen.
One of the particular areas of concern of some who have made submissions to the Royal Commission has been a concern about identification on patients' medical records of their Jewish religion and concerns expressed about that occurring. Is that a matter that would be something that would be considered by the health ministers at that level, or would that be left to the individual states and territory ministers to?
So, based on my understanding, that would fall under the remit of each individual states and territory health minister.
Now, there's also been concerns raised in submissions to the Royal Commission with a perceived need for depoliticisation of the healthcare system, if I can put it broadly in those terms. Is that an issue of national health reform concern that has come before the health ministers' meeting?
I'm just not familiar with the term. It could be true, but the depoliticalisation of the health system, is that what you're saying?
Yes, to ensure that healthcare professionals and other participants in the healthcare system don't actively engage in political advocacy or activities in the course of their work.
So it would be similar to your last question, that would be within the remit of each individual state and territory. We generally we operate within a dissolved governance structure where each jurisdiction governs its own. The health ministers' meeting is a forum for collaboration and progressing some national health reforms.
It would be possible for one or more of the ministers of the jurisdictions to bring that issue forward for consideration at a national level, though, wouldn't it?
So the forum is available for members to bring forward initiatives that they're looking for collaboration and national consistency. So I've never seen this particular topic or a similar topic raised, but the forum is used for that reason.
And you may not be able to address the substance of the proposition without authority from the ministers, but what do you say to the general proposition that it's not appropriate for healthcare professionals and staff of hospitals to express their political views to patients and their families and carers while they're being given healthcare?
Yeah, so it wouldn't be me getting their permission. It's just more I wouldn't be able to speak on behalf of ministers. I think if I speak on behalf of myself, I feel like everyone should feel safe and respected, and to go with, I guess, while they're in the healthcare setting.
Thanks, Mr. Duck. I don't have any further questions.
Yes. Mr. Borski.
We had applied for leave for short cross-examination too. Is that convenient now?
Yes. Well, Mr. Borski, any idea how long you'd be?
3 or 4 minutes.
Ms. Callan, do you have some re-examination of this witness?
Not at this stage.
Let's plough on.
Thank you, Commissioner. Mr. Duck, you were asked some questions by Council Assisting about the adoption or application of a definition of anti-Semitism. You recall those questions? And were you in the hearing room this morning when evidence was received from a gastroenterologist, Dr. Gordon?
Unfortunately not. I was on the tarmac, dramatically delayed.
We've all been there. We make no criticism of you for that. I'll just let you know that the Commission heard evidence this morning from Dr. Gordon in response to a question from the Commissioner that there's something of an inconsistency between national boards and AHPRA in investigating anti-Semitic conduct by health practitioners, because national boards are not required to consider or apply the AHPRA definition, whereas AHPRA has adopted the definition and does consider it. Are you aware of that issue?
I'm not aware of it, but I'm also not in an informed position, I think, to be aware of that.
Well, you know, don't you, that the Health Ministers' meeting has power to direct the health professions via their national boards to apply or consider AHPRA when exercising their functions?
Basically, from what I've read in the documents that have come in from Minister's consideration, I believe they have the power, yes.
Yeah. And you know that the Health Ministers' meeting has not adopted a definition of anti-Semitism?
It hasn't been raised in the Health Ministers' meeting.
You know that they haven't adopted a definition?
By default, yes.
And do you know that the AHPRA definition has been adopted by the federal government and is supported by the state governments in Australia?
I haven't looked. Sorry.
Are you able to well, I put to you that the Health Ministers' meeting should direct the health professions via their national boards to apply or consider AHPRA when exercising their functions. Appreciating you can't speak on behalf of the ministers collectively or even individually, are you able to make any response to that suggestion?
No, I'd only be able to comment on how the process works in Health Ministers' meetings, so I wouldn't be able to comment on whether they should or shouldn't do something.
And in terms of how the process works, it's plain, isn't it, that the Health Ministers' meeting has the power, as you mentioned at paragraph 14 of your statement?
To issue the policy direction under the national law to AHPRA and the national board. My understanding from reading the documents that I have is that they have the power to issue a policy directive.
Yeah. We just saw an example of what Mr. Lancaster took you to.
Yeah.
So there's nothing that you're aware of that as a matter of power or procedure would prevent a direction requiring the national boards to apply or consider the AHPRA definition?
Yeah, I definitely wouldn't be able to comment on that because I don't know the national law to that degree.
Thank you, Commissioner.
Thank you, Mr. Vorstein.
Nothing arising.
Anything arising? Thank you, Mr. Duck. You are excused. And I'll adjourn till 2 p.m.
All stand. The Royal Commission on Antisemitism and Social Cohesion is now adjourned.
Commissioner, I call Justin Untersteiner.
Yes.
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say, I do.
I do.
Please state your full name.
Justin Untersteiner.
Your address is known to the Royal Commission. You are the Chief Executive Officer of the Australian Health Practitioner Regulation Agency.
Correct.
You've prepared a written statement dated 13 July 2026.
Correct.
The contents of that statement true and correct to the best of your knowledge and belief?
They are.
Commissioner, I tender the statement. It has the ID STAT.899.001.0484.
Yes. The statement will be admitted as an exhibit.
You joined AHPRA as CEO in April 2025?
That's correct.
And you have a legal background. You previously led major compliance and regulatory programs for government bodies?
Correct.
And your career has been focused on consumer protection and government safety?
Correct.
Now, can I ask you about the role of the agency at a general level? What is AHPRA's function in relation to the regulation of healthcare professionals?
Sure. So AHPRA, our primary role as AHPRA is to work with the 15 national health boards to regulate health practitioners who are registered within the law. There are 16 professions within 15 boards. The role that's played between AHPRA and the national boards includes everything from setting accreditation standards for training organisations of health training through to the registration of health practitioners in Australia, through to the regulation and oversight of those health practitioners, which includes almost 1 million health practitioners.
Yes. Now, the national boards represent each of the particular areas of health practitioner, and their membership constitutes that close to 1 million practitioner figure that you mentioned.
That's correct. So we play complementary but distinct roles under the legislation, and so AHPRA we will accept, as an example, we'll accept complaints that we receive from the community as it relates to health practitioner conduct. We would then work with the national board to assess whether that requires investigation, and then AHPRA would undertake the investigation, but then make a final recommendation back to the appropriate national board. And so again, and then ultimately it will be a decision for the national board to make about whether or not to take action or to refer to a relevant tribunal.
And what of complaints that are made direct to one of the national boards? Does AHPRA become involved with the consideration of those notifications?
Complaints wouldn't go directly to a national board. There wouldn't be a pathway to go to a national board. There is a established process which can where anybody can either contact us by phone, write to us, or log a complaint through our online website, and we would collect those complaints on behalf of the national boards.
Yeah. Your statement indicates that the usual process would be that the decision-making function for any disciplinary action that might occur against a health practitioner would rest with the relevant national board?
That's correct. So after an investigation has been undertaken by AHPRA, the investigating officer will make a recommendation and provide a report to the relevant national board for consideration. The national board then has several options within the legislation at their disposal. That includes a decision to take no further action because they believe that there hasn't been either there has been appropriate action already taken by a practitioner to remediate the issue, and there is no longer a risk to public safety, or because there was no finding of misconduct or unprofessional conduct. The second option would be that they can take particular action, and that could include taking immediate action to protect the public, or it could be, for example, imposing a condition on the practitioner. And then they have a third and fourth option, which includes referring to a other relevant decision maker. And so that would include a state or territory tribunal. So wherever a national board forms a view that there was likely professional misconduct, it must be referred to a state or territory tribunal. That decision can't be made by the national board. And then there are some other rarer occasions where they can refer a matter to a particular professional standards panel as well.
Thank you. And AHPRA's position is that it would not itself ultimately decide the substantive merits of any complaint notification. Is that right?
That's correct. Again, decision making within the legislation falls with the 15 national boards.
You've indicated, though, in some circumstances, AHPRA may supply one of its staff as an investigator to the national boards, or one or other of the national boards, to assist with an investigation and resolution of a notification.
That will always be the case, yes. So an investigation will always be conducted at the request of a national board by AHPRA staff. So once a complaint, or what we call a notification, has been submitted, a brief will be provided to the relevant national board to ensure that on the surface it requires an investigation or not. If they determine that on the surface it requires an investigation, they will then allocate that to AHPRA to undertake the investigation. We'll undertake the investigation and again we will make a recommendation and provide a report back to National Board to make a decision under the law.
AHPRA is committed to eliminating anti-Semitism in healthcare. Is that a fair comment?
Absolutely, we are.
AHPRA has, for the purposes of its consideration of complaints that raise the concern of anti-Semitic conduct, has adopted the AHPRA definition?
That's correct.
And when did that occur?
That occurred in June.
June this year?
June this year, mid-June 2026.
Yeah. And previously, how did AHPRA approach anti-Semitism in terms of identifying it if there was some dispute about whether or not it had actually occurred?
So I think just in terms of some context here that might be helpful is prior to October 2023, AHPRA received very few complaints that related to anti-Semitism. So in the year leading up to that date in 2023, we'd only received 4 complaints that related to anti-Semitism out of more than 10,000 complaints that we receive. And although we take every complaint very seriously, it was a relatively low number. After that date, we did see an increase in complaints, and as a result, we started to undertake further actions to ensure that our organisation was capable of identifying and dealing with anti-Semitism in the health system. And to give you some examples, prior to our adoption of the AHPRA definition, we had undertaken steps such as we had developed a team that is focused on dealing with complaints that related to racism and discrimination, including anti-Semitism, to ensure that we had consolidated capability and expertise in that team. We had undertaken additional training over and above our core mandatory training that relates to racism and discrimination, in that we partnered with the Melbourne Holocaust Museum, first of all, to have specialised training of our staff. And then beyond that, we worked with the Australian Centre of Jewish Civilization to develop bespoke training for our staff that handle those complaints, as well as our senior leaders, including myself as CEO, to make sure that we had a strong understanding of what anti-Semitism, how it plays out. And in addition to that, we're bound by, as I mentioned, legislation, but we then have other key, structures that help us and help the boards to make decisions, including codes of conduct for professions. And the codes of conduct are also very clear on the need or on the role that practitioners play in eliminating racism and discrimination, and importantly, the conduct that's expected. So again, applying all of those things, we had many tools that we were using to ensure we could handle those complaints, but we did feel after further consultation that it was beneficial to adopt AHPRA as well.
You've referred to some training that was undertaken by AHPRA staff, including yourself. When did that occur? When did those training sessions take place?
Sure. The training with the Melbourne Holocaust Museum took place in 2025. I believe it was mid-year in 2025. I don't have the exact date. And again, that included all members of the team that are dealing with complaints that relate to anti-Semitism. And then we undertook further training with the Australian Centre of Jewish Civilization in early February this year. And that was held face-to-face with the centre, and again included all the teams that manage complaints or surround the complaint process that relate to racism, discrimination, and the senior leadership team at AHPRA.
And could you give the Commissioner some idea of the numbers of staff who are involved with dealing with complaints and who receive that training?
Yeah, so we have at the moment, it varies, as you can imagine, like any business with people that can come and go, but on average we have about 10 to 12 people within that team. The number of complaints that we receive, again, are relatively low, but again complex and very sensitive. And so we've made sure that we've staffed that team to be able to handle those complaints effectively.
You may have heard the evidence of Mr. Duck, did you? Or you weren't here for that?
We had some issues on the screen outside, so we heard bits and pieces of it. It was cutting in and out.
There was some AHPRA correspondence, which was the first update for 2026, that had an attachment that your agency prepared that I think referred to 449 notifications in the period from July 2023 to earlier this year.
Yep.
And that included the information that was about 1.6% of all notifications, and the 449 were in respect of racism and discrimination. Is that the position?
That's correct.
And a subset of those might have raised concerns about anti-Semitism?
That's correct.
Yeah. And is that figure of 1.6%, is that held true for the year to date?
I don't know the exact percentage, but it would be about that. I can share with you an updated figure. So if I look at the last 12 months, so the date of 1st of July 2025 up until the end of June 2026, we saw 191 complaints that related to racism and discrimination. Of those complaints, and that was against a backdrop of about 13,000 overall complaints in the system. Within that number of 191, 40 of those complaints related to anti-Semitism, 19 complaints related to Islamophobia, 9 complaints related to racism against Aboriginal and Torres Strait Islander people, 44 related to other forms of racism, and then the remainder were non-racism based discrimination. And again, that's a fairly relatively consistent pattern that we've seen over the last several years.
And what form the bulk of the 13,000? Are they related to healthcare provision?
Correct, yeah. So complaints about clinical treatment, right through to serious issues such as sexual misconduct.
Yeah. You've indicated the correspondence between the timing of AHPRA's adoption of the AHPRA working definition with the release of the Special Envoy's handbook. Can you explain how the contents of the handbook affected the decision of AHPRA in that respect?
Of course. We have been liaising very carefully with different community organisations and community members to hear different perspectives about the experience that they're having in the healthcare system, as well as the role that we should be playing as a regulator of health practitioners. And again, that's helped really guide the steps that we've been taking to develop new strategies that are aimed at stamping out anti-Semitism of the healthcare system and to help people feel safe when they enter into the healthcare system. We had not yet adopted a definition. We had resisted that for a period. And we had done that on the basis that we were certainly hearing some concerns about the risk of the AHPRA definition stifling free speech, legitimate, safe free speech in the health system. And so we had been working with a number of parties, including the Australian Special Envoy Combating Anti-Semitism, to share what we were hearing and to hear feedback and to better understand what that looked like. Very helpfully, I believe it was in April this year, the Australian Special Envoy Combating Anti-Semitism released a new handbook. And the handbook really went through, provided greater granularity and detail about the definition, about what it does mean and what it doesn't mean. And some examples include, it's very clear that the criticism of the Israel government, for instance, would not constitute anti-Semitism, and that's often where there has been criticism in the past. It also, is very clear that it's not to become part of law, for instance. It's a reference tool to be used in a system. We found that exceptionally helpful. And it was on the basis of that handbook, as well as all the feedback that we'd have over a period of time, that we felt it was the right decision then to adopt it into our organisation and scheme.
And how is it that it has been implemented into the organisation? Is there a training on the working definition, or how has it worked?
So we're still in early days, so we've only adopted it very recently. And part of the work that we're doing at the moment is we are building it into our operational guidelines and processes for our staff. So that ensures that staff know when to reference the tool and how to reference the tool. It ensures that it's built into different steps of our regulatory process, from triaging complaints at the front end right through to defining a complaint and categorising complaints as well, through to recommendations that will be made to a board. So that's still in draft, so that is not finalised. We're working through that. We continue also to engage with key members of the community. We engage with the Special Envoy, but also, for instance, with the Australian Centre of Jewish Civilisation as well, and other organisations, to help us understand how to do that appropriately. But in the meantime, we've also, to provide clarity to health practitioners, we've started already to provide information on our website, again, about what the adoption of the definition is and what it isn't, because there has been, we have had some concerns from some segments of the community that we will, it'll mean that we will be taking regulatory action where there is legitimate free speech, and we've been very clear that it is unlikely to happen. Of course, it's based on the circumstances and the evidence of every case, but that is unlikely to occur.
And then how does the adoption by AHPRA of the working definition affect, if at all, what the national boards might do when they consider a complaint for those particular areas?
Even though AHPRA adopted the definition, it really applies to the national scheme, including the national boards. And what I mean by that is the national boards are bound under the law, by obviously the law itself, by standards that are approved by ministers, including registration standards and standards on professional indemnity insurance and other things like that, as well as the codes of conduct. So that's what the boards are bound by in making decisions. However, AHPRA has a range of reference tools that we then use to support the making of effective decisions. They're not adopted by national boards ever. That's not how we're structured. National boards don't adopt reference tools. And the reason for that is because AHPRA are undertaking the investigation, we will use those reference tools in the investigation, and we will reference them in the final report and recommendations that are made to the national boards. So in that sense, the national boards are applying AHPRA definition through the way that we operationalise it within AHPRA and the way that our structures work, that we make recommendations to national boards. So again, it would be very unique for the national boards to adopt AHPRA in itself, because they wouldn't normally adopt a reference tool. That's not how we are structured or operate. But again, they're very much guided in making the decisions through the reference tools that AHPRA uses.
So the codes of conduct for the various professions, they're not entirely uniform, are they?
No, there are some differences across the codes of conduct, but we are certainly trying to work towards uniform codes of conduct into the future. We haven't got set timeframes for that, but that is certainly something that we're working towards.
And when any particular national board comes to make a final substantive decision in response to a notification, for example, when the issue raised is one of discrimination or racism, they make that decision, or the board will make that decision according to the terms of the Code of Conduct and make a determination about whether or not there's been a contravention.
That's correct.
Yeah. And in making that determination of a breach or a contravention of the Code of Conduct, the board will be applying what it understands the Code of Conduct to refer to as racism or discrimination.
Correct.
And is the effect of your evidence an expectation that the national boards would use as a reference tool the AHPRA definition when they're making that sort of determination in the context of a complaint about anti-Semitic conduct?
Correct. So the I know we're talking about a hypothetical here, but along those lines, we would likely see in that situation that if AHPRA had made a recommendation that there'd been some kind of breach of the duty that the practitioner has on the basis of anti-Semitism, that the recommendation and the report that is made to the particular board would very much reference AHPRA. It would reference how AHPRA has applied, and it would be built into that process. So again, by virtue of that process, the appropriate board would be referencing AHPRA in making that final decision.
To your understanding, the boards respectively would be doing that not by virtue of some direct legal obligation to apply the working definition, but by use of the AHPRA working definition as a reference tool in the way you've described.
That's correct, and again, that would be normal practice within the organisation. We use a range of different reference tools, human rights, the Australian Human Rights Commission reference tools and others regularly in the work that we undertake, even though they're not necessarily in many cases legally binding.
And your statement indicates AHPRA is working on other reference tools at the moment, including a definition of Islamophobia. Is that right?
That's correct. So we have adopted now a definition around cultural safety for Aboriginal and Torres Strait Islander people.
Cultural safety, did you say?
Yeah, cultural safety for Aboriginal and Torres Strait Islander people, and that was developed by Aboriginal and Torres Strait Islander health leaders. We've now adopted AHPRA as a working definition, and we're now consulting at the moment with key community groups in relation to a definition for Islamophobia.
Muslim community groups? Or?
Correct. So we've been liaising, we have a number of groups that we liaise with, but to give you an example, the Special Envoy Combating Islamophobia, as well as the Islamophobia Register of Australia are two examples.
At paragraph 45 of your statement, you indicate that AHPRA has a case management system by which it tracks notifications, including those that allege racism, discrimination or anti-Semitism.
Correct.
And overall complaints involving racism or discrimination form a very low percentage that you've identified.
Correct.
You've included in paragraph 50 a table setting out excuse me, data for notifications received since 2024.
Correct.
And just to pick up table 2 at the foot of page _0009 and over the page to 10, that refers to the 191 racism and discrimination-based notifications received, and they're the numbers that you summarised a little earlier.
Correct.
Right. And can I just ask on the next page, the notifications relating to anti-Semitism, as you've have in the table, 49 in number?
Correct. So that's, to clarify, that's the number of complaints that had been completed.
Completed in that year?
In that year.
Yeah. And then there are 73 which raise racism and discrimination-based complaints generally, which carried over into July.
Correct.
Right. In paragraph 52, you've noted that data relating to notifications about racism and discrimination need to be understood in the light of systemic or cultural barriers that can affect reporting. Could you elaborate on that?
Yeah, I mean, there is quite a lot of evidence that racism and discrimination can be underreported. And that can be for lots of different reasons, including fear of identifying themselves, fear of retribution, There can be cultural differences and fears in engaging with large institutions, for instance. There are a range of different reasons why someone may feel uncomfortable in raising an issue, so we're always very careful with this data. This is what we have in terms of the number of complaints that we have, but it's not always a true representation of the experience that people might be having in the system.
And is it too early to tell yet, or is the adoption of the AHPRA working definition been a useful reference tool to have at AHPRA's disposal?
It's very early to tell, but I certainly would have a strong view that it will be very helpful for us. Again, I think we're dealing here with often individuals that are very stressed and concerned about an experience that they've had. You may have a practitioner who's in the same situation as well, and to have a reference tool such as AHPRA that helps us to categorise and define and think about how we tailor our approach based on that, I think can only be helpful and can only ensure that we're more effective as a regulator, but also that our system is safer for those that are engaging with our system.
Now, the Health Ministers' meeting provided a direction to AHPRA and the national boards last year.
Correct.
And AHPRA was required to provide the 6-month update, which it did.
Correct.
And can I take you to the update? It's at least this, we've been to it earlier today, but I think the version attached to your statement, or the copy attached to your statement, is ahp.0001.001.0051.
Yes, I have that in front of me.
Now, on page 2 of the correspondence, in the first paragraph, you've indicated that steps are being taken in response to the direction, are being guided by an expert racism and discrimination steering committee.
Correct.
Could you explain the composition of that committee and its function?
Sure. Just to probably provide a bit of extra context here to may be helpful, is prior to the direction from ministers, we had already commenced a program of work to ensure that we were taking further steps to eliminate racism in our system, including anti-Semitism, and obviously a focus on anti-Semitism too because of the numbers that we've seen. And so we've taken we had already taken a number of steps, and then we continue to take a number of steps. In doing so, and to help guide our work, we felt we engage with many different groups and individuals in our system. We need to. We have a very diverse system, and so we need to do that. But we also saw merit in standing up an external committee, external to our organisation, that could help guide our work on racism and discrimination as an organisation, and to challenge us as an organisation as well, and to be at arm's length. And so we have a group, so just to give you one example, we have the Race Discrimination Commissioner from the Human Rights Commission is one of the members of that group. And we have it's a diverse group of individuals that represent different communities, including Jewish communities and Muslim communities, for instance. And again, they meet on a regular basis. They oversee the program of work that we're trying to implement. And again, they challenge us to ensure that we're taking the appropriate steps that need to be taken.
One of the attachments to your 6-month progress report underscored 0007 was a table setting out various focus areas and the action that AHPRA's taken in respect of each issue. Can I just ask about a couple of those? The first, on page 7, is the notifications process dash practitioners. Could you describe the steps taken under that focus area?
Sorry, could I ask you to repeat that question?
Yeah. Notifications process practitioners is the first entry in the table.
Yeah, sure.
Could
So
you just identify what's been done in that respect in the last 6 months? Or
the process, yeah. So we have been, again, we had already started to take steps to ensure that thank you for that, that's very helpful to have it on the screen. We had already commenced taking steps to strengthen our notification processes as it relates to racism and discrimination. So again, an example was ensuring we had a dedicated team that we could skill up that would deal with those complaints in a consistent way. That's one example, as well as the training that we'd undertaken as well. But we've gone further than that now, and we have undertaken review of all complaints that related to racism and discrimination since July 1, 2023 through until February this year. And through that identified strengths in the process, but also identified where there are weaknesses in our processes. And through that, we will now be taking a series of actions to improve the process for all using our system. And to give you some examples of what's included in that, we identified at times there could be some inconsistency in the application of our frameworks in undertaking an investigation, which means in some cases there might be a low risk complaint, which means there wasn't significant issues raised, but the investigation went further than it should have gone. And what that can do is that can cause stress for the practitioner who is subject to that investigation. There were some examples of the opposite of that too, where we think an investigation might have benefited from going further than it did. And so, and there were also issues about, for instance, communication as well, understanding that particularly when it comes to racism and discrimination, tailoring communication is very important because of the trauma that somebody is already experiencing. So one action that we're taking is to now look at our processes and our training to ensure that that is applied effectively. Another example is the application of our vexatious complaint framework. And so a vexatious complaint under the law is a complaint that lacks merit and ultimately is the intent is to cause harm, distress. And so we need to meet those two limbs to determine that it's a vexatious complaint. Again, we in reviewing all of those complaints, we believe there are times when there would have been merit in further investigation and assessment about whether a complaint was vexatious or not. Not to say that that would have led to the finding of a vexatious complaint, but we're not convinced that in all cases the framework was applied as well as it could have been. And so the action that we're taking there is we will be reviewing the vexatious complaint framework, and in fact we're in the process right now of establishing a lived experience advisory panel, which will include Jewish members who have got experience in our system, as well as other members such as Muslim members and other members who experience racism in our system, to help guide us in the assessment of the work that we've been doing and where we can make changes to the vexatious complaint framework. And so that's activity that we are undertaking as well. And then there were some other recommendations, including the need for us to continue to explore regulatory tools to identify risks earlier. So for instance, where we're seeing racism on social media, how we can identify that earlier to reduce the harm. And then importantly as well, the need to be adopting reference tools and other guidance to support our decision making.
In paragraph 28 of your statement, you've addressed the vexatious notifications framework, and you've said that while it's not common, AHPRA acknowledges that notifications, including about racism and discrimination, can be made vexatiously. So just to ask about your description, not common, how often did it occur, for example, in the 2 years of the data that you've presented?
In terms of the data that has been presented here, we had found one vexatious complaint that met the criteria for being a vexatious complaint. And just to, I think important to clarify, there can be confusion at times, not just at AHPRA, but I've worked in AHPRA for other regulators, where because we find that there was no case to answer for a practitioner, that doesn't make it vexatious. And sometimes that can be, people can feel that because, or a practitioner may feel, because we found in favour of the practitioner that it was vexatious. Again, from an evidentiary perspective, we need to find evidence of intent to cause harm. And so that is a bar that we must meet and can be difficult to meet at times. And so, but again, I acknowledge though that I think we can do better at applying our own framework, and that's why we've agreed to an action which we'll be implementing this year to improve that framework. and the application of the framework, importantly.
So as to better explain to all participants in the notifications process what is a vexatious complaint and what isn't.
Correct. So we currently have policies and processes for our staff. I think the opportunity now for us is to look at further training for our staff in how to apply the framework. But again, I think what's important here is to work with people with lived experience to understand their experience of the system, to help guide how we might revise the framework as well. So there's two parts to this. One is how our staff are trained and apply the tools they've got to apply the framework, but the second is looking at the framework itself to make sure it's fit for purpose.
At the other end of the spectrum, you've addressed in paragraph 29 circumstances in which conduct might pose a serious risk to persons and immediate action is necessary. Could you identify what the immediate action team is and how that might operate?
Sure. So again, one of our paramount responsibilities within the legislation is public safety. And if we are investigating a matter and we can see there's an immediate threat to public safety, either to an individual or a group of individuals, the national boards will have the power to take immediate action, which would be imposing some kind of immediate condition on a practitioner with the purpose of protecting the public. And that condition, again, it could be wide-ranging. There's a range of tools they can use, but I guess the one that is often talked about is that the boards would have the power to suspend a practitioner from being able to practice. And they would do that in very rare and extreme cases, but it's where we believe that there is again, a threat to public safety that is so high that immediate steps must be taken. And so, again, that is a tool that is used only in particular circumstances of very high risk, because the consequence we've got to balance the consequence on the practitioner as well. Immediately suspending a practitioner will mean that they are likely not employed and unable to work.
I'm sorry to interrupt,
No,
but the board would have that power to act promptly in relation to a matter involving a serious instance of racism, but the board itself would not determine the complaint. It would be referred to the appropriate tribunal. Is that correct?
That's exactly right. The immediate action is an interim step for public safety, whilst then a separate decision would be made about the referral to a tribunal, and then a tribunal would make the final decision.
And just to be clear, when you told us that there had been one complaint that was assessed as a vexatious complaint within the cohort, you were speaking of the complaints involving an allegation of racism between the 1st of July 2023 and the 28th of February 2026?
That's correct.
Thank you.
Can I ask you about AHPRA's policy on social media and by health practitioners? And if I could bring up the policy document, which I understand to be current, it's AHP.0001.001.0048. So is this the current policy? Do you need to see the third page to know? Perhaps I'll bring up _0003 immediately. So that shows an approval date in April 2024, a review date in May this year. Is this the current policy on social media?
I believe it's the current policy.
Okay. So if we could go back to the first page of the policy, please. How would AHPRA take this policy document into account?
In assessing a complaint that relates to social media, when I say social media complaint, I'm talking about the posting of something on social media, or possibly the commenting on an existing post, for instance. That would be most common. Our staff, in undertaking that investigation, would be they would use this policy to help guide their decision making. I think important to note too, we've also published information on our website, which is which we update regularly. It's been updated again recently, where we give also very specific examples about what would constitute a concern for us as a regulator in terms of posting something on social media versus something that might not. And so again, we would use all of those things in our for the purpose of that investigation.
And if I could just take you to the final paragraph on the first page, where the policy document indicates that AHPRA and the national boards recognise freedom of expression for practitioners and their right to communicate, including advocating for causes via social media, provided their activities do not involve the abuse or discrimination of others or a breach of the laws of their jurisdiction.
That's correct. We believe that health practitioners, like any member of our community, have the right to free speech and a right to express views about whether it be political issues or otherwise. But that right will be constrained if it starts to lean into discriminating against an individual or a group of individuals. Importantly, I've said this today already, but all Australians should have the right to feel safe in accessing healthcare, no matter what their religion or race or background is. And when we have practitioners who, for instance, post on social media in a way that is discriminating or causing harm to individuals, the effect of that is not just on the individual it's targeting, but it can actually lead to patients who need care not getting the care that they need. There is some often this can be misconstrued in that, for instance, AHPRA adopting the AHPRA definition means that people are no longer able to express their views about international conflicts, and again, that is not true. We will not get in the way, or we would not take a regulatory action for doing that as long as it's done respectfully and accurately. But again, as soon as that veers into discrimination or racism, we would then you'd certainly have the attention of us as a regulator.
And I'll perhaps take you to the second page of the policy document. So you've indicated, or the policy document indicates in the first full paragraph of the page, that there are only limited grounds on which AHPRA or the national boards would take action in relation to use of social media. But you've identified, or the document identifies in the bullet points, the expectation on health practitioners in respect of the use of social media, and as you've referred to, that includes complying with the relevant national board's code of conduct.
Correct.
And it's right, isn't it, that the codes of conduct often deal directly with use of social media in a way that indicates a connection between the health practitioner and the health organisation with which they work.
Correct.
And constraints are applied in those circumstances.
Correct.
And one of the document's other bullet points is an expectation to communicate respectively with or about patients, colleagues and employers.
Correct.
Now, from AHPRA's perspective, in what circumstances are healthcare practitioners acting in a private capacity when they use social media, if that can be described in general terms?
Very rarely, I would argue. I mean, again, I think there is a social media is generally very public. I've heard it described by other witnesses today. There is a special relationship that and a special level of trust that is placed in a health practitioner in our health system, and I believe it becomes an artificial argument about whether someone is acting in a private or sort of their public capacity. The damage and the harm can be all the same. And so again, if there is information that is made public through social media that discriminates or is racist, for instance, the harm still exists for the practitioner. And so in that situation, we would still be inclined to investigate a matter regardless of whether it was provided in a public or private capacity.
In other words, so long as it's identifiably posted by a health practitioner, you would
Correct.
have a look at that if the circumstances call
Correct.
for it.
Correct.
you refer in paragraph 54 of your statement to AHPRA using social media monitoring tools. Are you able to go into that without disclosing operational details?
Yeah, I mean, we, like most regulators, use a range of different regulatory tools to identify harms and risks. That includes the use of social media monitoring tools, which again are very common for regulators, that help us to identify where there might be either trends that are emerging that concern us, that could relate to, for instance, racism or discrimination, or potentially where there is cases of racism and discrimination as well. And so again, it's I guess a regular tool that would be used by regulators, amongst other tools that we use as well, to ensure that we are able to minimise harm to the public and fulfil our role in terms of protecting the public.
You've also referred, this is in 54D of your statement, to reviewing and strengthening codes of conduct and CPD requirements, continuous professional development requirements. Could you explain what has been involved with that?
Sure. We are currently undertaking a review of both of those things. So the codes of conduct, we are undertaking a review of the codes of conduct for all professions part 1, and the only reason that there is one that isn't included is a timing issue, because at the moment we're still not on a single code of conduct. There is just a timing issue, but we will get there as well as broader CPD requirements. These will be comprehensive reviews that are undertaken with broad public consultation. And again, we will be, if I use the codes of conduct as an example, we are hoping to use our lived experience advisory panel that I mentioned earlier to also support us in the review of those codes of conduct. And the goal is to ensure that we can roll out an updated codes of conduct likely next year, that again continue to mature and adapt to the different risks that we're seeing in the environment, and support practitioners to be able to undertake their role effectively and safely as well. The CPD, continuous professional development, likewise we've undertaken public consultation. That's now closed, but we're still consulting with particular groups to obtain further information about what that will need to look like into the future as well.
In relation to the steps taken with the CPD requirements, is it also intended that AHPRA move to a common CPD regime for the various different national boards?
Yeah, I think as a general approach, we've been working collectively with the national boards to look at where we can apply more consistent approaches across professions where it makes sense to do so. There will be some circumstances where it doesn't, because of unique circumstances surrounding different professions, but as a general rule, we're trying to move to much more commonality and consistency, and there's certainly a strong willingness by all chairs of those national boards as well as our organisation to do that.
You give in your statement one example of the Medical Board of Australia's CPD framework, and you refer to this in paragraph 36 of your statement, and you say that requires medical practitioners to engage in CPD activities that include core content on culturally safe practice, addressing health inequities, professionalism and ethical practice. Can I just ask you about that? One of your references is to the Medical Board's CPD framework. It's AHP.001.001.0017. It's the Medical Board's registration standard on continuing professional development. So if we go over to page _0002, that's 3, I think. Go back to page 2. Thanks. Under what CPD am I required to do? So this is for medical practitioners referring to their 50 hours per year of CPD activities?
Correct.
I couldn't see in this document where it referred to these core content of culturally safe practice and so on. Is that contained within this document or in another document?
I am not sure. I know it is referenced in either further in this document or in another document, but I would be happy to provide clarification after the hearing.
So in relation to the medical practitioners CPD, that is largely self-determined and self-evaluated, isn't it?
That's correct.
Yeah. And so is there anything that would require, for example, a medical practitioner to undertake at some point a CPD activity that relates to racism and discrimination, including anti-Semitism?
So at the moment, no, that's not a specific requirement. Again, the general principles of CPD as they apply, it's a principle-based system, because again, if I go back to my earlier comment, because we have 1 million health practitioners, the requirements and needs of practitioners will very much vary to the individual. And so ensuring that they are applying CPD to the areas that matter most, where it's most needed, we think is important. And so again, we, as a rule, the boards don't apply a step-by-step approach of what needs to be undertaken, but instead provides principles about what would be expected to be taken.
So it's not content-based to the extent of saying there needs to be a CPD unit at some point on racism and discrimination?
No, that's correct.
Right. And is one of the things that AHPRA is considering at the moment whether that principles-based approach should be adjusted to include some content-based requirements?
I wouldn't want to preempt the outcome, and again, I guess just to provide some clarity in terms of roles and responsibilities, the codes of conduct the CPD requirements are developed by the national boards, and so the national boards are undertaking that consultation at the moment, and will ultimately make a decision about how that will change. And again, I wouldn't want to preempt what the outcome of that is.
One of the other matters you refer to in paragraph 54 is rolling out a media campaign entitled Racism and Discrimination Costs Lives. What's the timeline on that, and what's the broad nature of the campaign?
Sure. So we continue, if we think about education of health practitioners, I guess you could sort of bundle it into several areas of education. As it relates to our role, that is. I mean, education comes from lots of different players in the system, but as it relates to our role, the first is the setting of accreditation standards to ensure that practitioners are trained effectively, and we are working with our accreditation authorities to ensure that we are embedding issues of racism and discrimination into accreditation criteria. Again, what we want to do is we want to get to the front end and ensure that we're training safe practitioners from the beginning, and that's really important. A second lever that we have again is our CPD requirements, which we've been talking about, as well as the codes of conduct, which are really important, and then the tools that we have around that. But then we also have a broader education role that we can play through things like media releases and broader campaigns. So we undertake a range of different activities. The campaign you've mentioned is one where we ran a large-scale media campaign and social media campaign reminding practitioners of their role and their obligations. We've established dedicated websites now with reference tool or with tools for practitioners to be able to get further guidance on what is expected of them as well. And we had a large reach of that throughout the community. But it's not the only. We've released a whole range of different activities to educate practitioners, including even regular updates on our expectations in, for instance, profession newsletters. Like, we really try and target all angles, because again, with such a diverse audience, not all will be on social media. You need to tackle it from different ways. So we've been undertaking a range of activities, which again, it's about explaining our requirements as it relates to racism and discrimination, and giving examples and further guidance and tools for practitioners to apply.
Thank you. On the 23rd of July, less than a week ago, AHPRA and the national boards prepared a document on the review into AHPRA's management of notifications relating to racism and discrimination.
Correct.
Can I bring that up, please? It's AHP.001.001.0052. So what was the purpose of this document? Is this for provision to the health ministers, or is this to be publicly released, or what's the...
We have publicly released a summary of the report, which outlines what the review related to, what it found, and what actions that AHPRA will be taking to address the issues that were found within the review. And that goes back to my earlier statements about the review and, for instance, the inconsistency in the application of the vexatious complaint framework. So that is the report I was referencing earlier.
Is there any particular part of this document that you haven't addressed in answer to my earlier questions that you'd wish to highlight about AHPRA's response to these issues?
There is one thing I would like to highlight, because I think it is an interesting and probably concerning statistic as well, which is when we undertook this review, what we found was overall complaints that relate to racism and discrimination had a connection to social media in about 40 to 45% of cases. However, when we focused on Islamophobia and anti-Semitism, that went up to 85%. And so what it tells us is that there is more likely to be a complaint that relates to social media as it relates to anti-Semitism or Islamophobia than it is for other forms of discrimination or racism. And again, it just shows the role of social media playing in society at the moment. And again, I guess the other observation that we'd make there is the connection then to the media reporting that is surrounding these issues as well.
Perhaps if I can bring up page _0003, which is a summary of the data that's involved. And I think in the bottom right quadrant of that page is the statistic that you've just addressed, namely that when, in respect of matters raising anti-Semitism or Islamophobia as the subject of the notification, 80 to 85% of that has been sourced in social media.
Correct.
And then in the top left of the summary document, that perhaps is a slightly different time period reflecting the slightly different number, the 477.
That's correct. It's just a different reporting period.
Yeah. But the balance of the character of the notifications as between anti-Semitism, Islamophobia and other forms of racism, as shown on the left, broadly aligns with the proportions that you identified earlier.
Correct.
And the other part to note is this most recent report's update on the time to complete a notification, which shows the substantial decline in the number of days that it takes to finalise a complaint.
Correct, and that change I think is a welcome change. We know that delays in handling a complaint can cause further harm for both the person who's made the complaint as well as the practitioner, and again that can be exacerbated when we're dealing with issues of racism. And so if I go back to many of the steps that we've taken around training, dedicated teams, the way we're handling complaints, those have now resulted in significant improvements in our timeframes. We've more than halved the timeframe it takes to handle a complaint as it relates to racism or discrimination.
You say here that, again, I'm sorry, looking at the page that we have in front of us, 406 of the notifications resulted in no regulatory action, and you cite the various reasons for that. The practitioner might have undertaken education voluntarily, the concerns might have been dealt with elsewhere, or the concerns might not have been substantiated. Do you have a more precise breakdown?
I don't on me, Commissioner, but I'm sure that's something we may be able to get. I would have to check that. It's a really important point, though. I think there is sometimes and I can understand why people would draw this conclusion, but when they see no further action taken, the assumption is there was nothing to see, and that is not always the case. And because of confidentiality, we can't share that with all parties. But the reality is there are cases where we're seeing lower risk conduct, but where we can see that a practitioner has taken real steps to remediate their behaviour. They show remorse and understanding. And again, in those situations, the board will then balance the further risk to public safety, and in cases will close that complaint on that basis. And so just because complaints might be closed with no further action, it doesn't mean there haven't been steps taken to reduce risk.
Yes, and it's a question of privacy that makes it difficult for the regulator to convey to the complainant that there was a satisfactory outcome. The health practitioner undertook some education voluntarily or the like, but you're not in a position to go into that sort of detail.
That's right. I guess it's a tricky position we're in that we aren't able to communicate to all parties what that outcome was because of confidentiality, and so that is a challenge.
The final question that your statement addresses, the question asked by the Royal Commission and addressed in your statement, is whether there are any other recommendations or proposals to counteract and prevent manifestations of anti-Semitism. And in that context, you've drawn attention to the fact that AHPRA regulates registered health practitioners, but does not have jurisdiction over healthcare settings or policies that are in place in respect to healthcare staff in the workplace.
Correct.
Could you explain that limitation on AHPRA's role?
Sure. So, I guess monitoring, so maybe a different way to put this is ensuring that our health system is safe is really a role for a range of different organisations, not just us as the health practitioner regulator. We play a very important role, one we take extremely seriously, but it's really a system that relies on health services, for instance, the states and territories, for instance, specialist colleges and colleges for professions. There are a range of different parties that need to play really important roles in ensuring we keep the system safe. And so we certainly feel like we're taking the right steps to protect the community, but it also does require, again, for instance, in health services, that they've got the right policies and procedures, complaints processes, for instance, as well, to be able to identify and deal with racism. And so I guess it's a comment highlighting it's a complex system, federated system that we have here in Australia, and it will take the effort of all parties involved to make sure that the system is safe for all accessing healthcare.
And does AHPRA participate in any structure which involves liaison or engagement with, for example, the workplace providers of healthcare services?
Yeah, we do. We have a range of different mechanisms to engage with, whether it be employers or health services. We have arrangements to deal with the jurisdictions, so the states and territories, to engage with the Commonwealth of the federal government as well. So we do have a range of different mechanisms to do that. And again, we do provide feedback, and we receive feedback. And again, I think that intelligence and insight is really important to ensure that systems can improve.
Thanks. I don't have any further questions, Commissioner.
Yes. Well, now, leave has been granted to you, Mr. Borski, and to you, Ms. Edwards. Is there any disagreement between you about the order?
Well, I haven't discussed it with my friend Ms. Edwards, but I did discuss with Mr. Lancaster that she might perhaps go first.
Yes, very well. Ms. Edwards.
Thank you, Commissioner. Mr. Untersteiner, my name is Kirsten Edwards. I'm here for the Jewish Council of Australia. If I could start with asking you some questions about the notification process that you've just been outlining to Council Assisting. You've outlined in your statement and your evidence today that the process that AHPRA and the National Board undertake when a notification is made, and you've gone through that at paragraph 10 of your statement. An aspect of that is a preliminary review or assessment by the National Board to determine whether there's grounds for the notification. Is that right?
Correct.
And I think you referred to that today as effectively a triaging process. Is that right?
No. So that is separate. So we have a triaging process we use at the point a complaint is lodged.
Yes.
is to be able to categorise that complaint into different categories, so understanding what profession it relates to,
I see.
what it relates to. So that's more of an administrative function that's undertaken. This is a function that sits within the law. It's a statutory function where the National Board will need to make an initial decision on whether, again, it meets the grounds within the legislation for us to investigate, or whether it meets the grounds for them to close the complaint at that earlier stage.
And that has a merit component to the complaint, yes?
Correct.
Now, if it passes through that initial threshold and it's not determined, as we're talking about, as to be vexatious, for example, there's an investigation which can be conducted by an AHPRA investigator, is that right?
That's correct.
And that can include, just to list some of the activities, gathering evidence, speaking to witnesses, arranging for expert opinions, and ultimately providing a report to the National Board along with those recommendations about what actions might be taken.
Correct.
And just describing those actions, I can assume that at times that process can be quite time consuming from a resource point of view and a time point of view for AHPRA.
Yeah, it very much depends on the nature of the complaint. And so you can imagine that we have some complaints that relate to extremely complex issues that require significant levels of evidence, witnesses involved, expert opinion, and that can be a more lengthy process as well. And then there might be others which don't take as long because of the nature of the complaint.
And at the end of that process, in the more extreme end, there are some quite significant consequences for practitioners if there's a determination that could be upheld, which can raise up into including suspension of their practice rights or condition on their practice rights. That's right?
That's correct. And just to, again, provide clarification, a National Board would only, they can place conditions on a practitioner based on what they find. They can impose immediate action in very rare cases where there is immediate risk to the public, but otherwise they would be making a referral to a tribunal if they felt that there was a professional misconduct issue.
But you'd accept that any involvement in the notification process can be, to a practitioner who's facing those things, a stressful process?
Absolutely. We've done a lot of work with health practitioners to understand the impact of our system on them. And we've undertaken a lot of work to improve our system to make sure we can minimise that distress. But again, we are well aware of the stress and impact that they can cause for a health practitioner.
And you've indicated today that perhaps that pressure or that stress can be elevated where the complaint might relate to antisemitism or racism or things of that nature.
It's possible, yes.
You would also acknowledge that some practitioners, even with a complaint that ultimately no action is taken with, can experience time, stress, expense even, responding to a complaint and going through that process?
Yes.
And you have developed a vexatious framework, in part because of a recognition that those processes can be, in certain circumstances, misused or weaponised, and that can cause a tremendous amount of distress to practitioners.
That's correct.
And that's undesirable, obviously.
Correct.
Now, it's obviously undesirable for the fact that no practitioner should unfairly be subject to time and expense and stress. But another aspect of that undesirability is that that might actually deter someone from taking an action that's legitimate, for example, engaging in free speech or genuine political debate. Do you agree with that? I'm
not sure that I can agree with that. I mean, again, I think I can't talk for what other individuals or groups of individuals that are quite diverse may think. But I'm aware, because I've seen some social media and media, that there are some practitioners that have concerns about their right to free political speech.
And one of the things, in fact, you said today, though, at the start of your evidence was one of the things that you took into account before AHPRA took on the AHPRA definition was you didn't want practitioners to feel like their legitimate political expression would be hampered or that they wouldn't be able to engage in that debate without being drawn into a notifications process.
Correct.
Is that fair?
That's fair.
And that's why it was so significant that the handbook got released, because that was a live concern that you had.
Correct.
And you'd accept, though, that if somebody goes through a notifications process and it's time consuming and it's stressful, but it's not substantiated and it relates to their political speech, that can still have a chilling effect on how they might engage in that speech in the future?
Yeah, I do. I will make a comment to that, though, which is one of the things that we are focused on at the moment, and particularly through our review of our complaint processes for racism and discrimination, is the way in which we will engage a practitioner, where prima facie there is no substance to the complaint, even if it's not determined to be vexatious. And it's for that reason is that what we don't want to be doing is creating stress and trauma for a practitioner where it's clear that it's very unlikely to be a regulatory outcome. And so that is one of the steps that we're looking to take, is how we ensure that we can assess risk, to ensure that if again, prima facie, we can see a complaint has come through that is just purely questioning someone's legitimate right political free speech, we are considering the option of then not contacting the practitioner to let them know about the complaint, so they don't have to worry about that and they don't have to feel that. And so again, that's something that we want to work with people with lived experience, health practitioners that have been through this process, to make sure that we get that balance right, because there is a mix here between transparency as well as safety of the practitioner.
Yes.
And we want to get the balance right.
There's also a flow-on effect, isn't there? Like, obviously you don't want to unnecessarily stress somebody out if it's not going to go anywhere.
Right.
But also, if they tell all their friends, I'm subject to this complaint because I've made this adenine comment, then everybody starts to feel like they can't make those sorts of comments.
Well, I think there is a possibility that someone could tell others. I don't know that it means that everybody feels that they can. Again, we've got a very large practitioner community, and so I wouldn't go that far. But I understand that if someone has that experience, they might tell some others. And again, though, I want to. That's why, though, the work we're doing is not just about how we handle a complaint in that situation. It's also about the education that we're providing to practitioners. And so again, we released information just last week, updated information on our website about the application of the AHPRA definition.
Yes.
To help clarify
yes.
where we won't be using,
yes.
Where we won't be taking regulatory action. And it's really important that we can help to provide as much certainty as we can in an environment that will rely on facts and evidence, but to help ensure that concern is not felt by practitioners.
Yes, and that's so important, isn't it? Giving practitioners guidance in a really concrete way about this is okay, this may not be okay. Is that
That's
fair
correct,
to say?
and that's what we're doing.
And that lets people feel free in their political engagement. But part of that is allowing things to be taken effectively off the table as being not allowed to be said.
Correct.
Do you agree with that?
Correct.
Now, I want to briefly mention a letter that AHPRA received prior to the adoption of the AHPRA definition. I won't take you to it unless you think I need you take you to it. But there was a letter sent by the Royal Australian College of General Practitioners, Dr. Michael Wright, about the notification process last year. You're familiar with the letter?
I recall a letter, yeah, I do.
Now, the aspect of that letter that I just wanted to raise with you, noting that a lot of things have changed since that time, is that the concern that was expressed in that letter wasn't so much that complaints about political speech were being substantiated, but that there'd been a large number of complaints made against practitioners who had expressed views about the humanitarian situation in Gaza, yes?
Yeah, correct.
And the concern was that first it was taking a lot of time to resolve those complaints, and second that it was causing immense distress to those practitioners, and you talked about some of the measures you've tried to take to resolve those concerns.
Yeah.
One of those has led to a reduction, as you told Counsel Assisting, in the average time taken to resolve complaints from, I think, 132 days to 54 days.
Correct.
Is that right?
Correct.
Although 54 days is still a couple of months, fair to say.
Yep.
If I could take you now to some questions about the handbook that was very critical to AHPRA in being a tipping point, if I can refer to it that way, in adopting the AHPRA definition. Is that fair to say?
It was certainly an important factor of several factors, yes.
Your statement says it was because the release of the handbook clarified the difference between legitimate political debate and anti-Semitism, including on the topic of Israel.
Correct.
And in particular, it supported the use of the definition by distinguishing between anti-Semitism and legitimate political debate, including on the topic of Israel.
Correct.
Now, and I think you've said earlier in your submissions that the goal of AHPRA is to have a well-informed, fair and proportionate complaints process that protects public safety but doesn't prevent non-racist expressions of beliefs about Israel. Is that a fair way of putting it?
Correct.
So is it fair to say that in that embedding process of the AHPRA definition that you detailed with Counsel Assisting, that the ASICA handbook and AHPRA go hand in hand in that embedding process? You're embedding the definition, but you're also embedding the handbook?
That's correct.
And so when you say, for example, that as far as the National Board is concerned, the AHPRA definition may inform a decision about the substantive merits, that would also include reference to the handbook?
Correct.
And that can therefore inform an assessment of whether or not particular conduct is anti-Semitic or racist?
Correct.
And will that also be used as a guide with the vexatious notification framework to guide whether or not a particular complaint is vexatious or not?
Yeah, well, we would use all reference tools available to us to make that decision.
So I'd like to take you now to a particular portion of the handbook that does give concrete examples. It's at AHP.0001.0001.0002.
You'll get used to it, Ms. Edmonds.
I'd like to take the witness to page 74 to 76. It's actually the second last and the last page, if that assists. No, it's at page 74 to 76. I think that's the document.
It's a different document.
No. The ASICA handbook.
The document. That's it.
Thank you. I'll just give you a little bit of time, Mr. Untersteiner, to have a look at that.
Is there a particular table, the top or bottom?
Yes, so there's a heading Appendix E, case study, the professional WhatsApp chat.
Yep.
And it says it's a hypothetical case study based on a real life scenario reported to ASICA. And if I could just pause there, you were answering some questions from Senior Counsel Assisting about social media. Could a professional WhatsApp group be subject to a complaint to AHPRA?
It would, well, there could be a complaint lodged with us about just about anything, I guess, to start with. You know, that's something that people have a right to make a complaint. But in terms of would we consider a complaint that relates to it, again, it would very much relate to the facts of the situation.
Yes.
So, you know, there's a difference, for instance, between a private group that 2 or 3 people that no one is seeing versus a group that has people from the workplace or a diverse community. And so again, I wouldn't want to preempt any decision, but
Yes.
it would depend on the facts.
Just to assure you, I'm not going to ask you to preempt any decision,
Sure.
but I will take you to this example because it is concrete, which we were talking about earlier. It's a scenario about a professional WhatsApp group that's advertising a march on the Harbour Bridge. So on the left-hand column, there's scenario. In the middle green column, there's a heading analysis. And then on the right-hand column, there's lived experience and impact. A Jewish WhatsApp member shares their reaction. Do you see those?
Yes.
So if I could take you now down to page 2, there's reference to a particular statement that's made by a member of that group that in response to someone who's posted a flyer about the Harbour Bridge March, and it says, "What about the genocidal racist Zionist project that has oppressed the Palestinians? Zionism is a supremacist ideology invented by Theodore Herzl. They've done this through apartheid and ethnic cleansing." You see that?
I can see that.
Now there's quite a detailed analysis under the analysis section, but the first sentence states, "This is anti-Semitic." Do you see that?
Yep.
And then there's a reference on the right-hand column to, I'll just quote part of it. "Unfortunately, what followed the earlier post was a response which was anti-Semitic because it included statements that accused Israel of apartheid, oppression, racism and genocide." Have you seen that example before?
I have read the handbook several times, so I've seen that.
Yes.
Yep.
So one reading of the analysis provided of this example is that describing or using the words genocide, apartheid or ethnic cleansing in connection with Israel's actions in Palestine is anti-Semitic?
Well, I would object to that because it doesn't
Yes.
refer to Israel, it refers to Zionism.
Yes.
I'm happy to be corrected. one reading of this is that that expression, what about the genocidal racist Zionist project that has oppressed Palestinians and so on? They've done this through apartheid and ethnic cleansing. One could take they as meaning Israel, could you not?
Oh, look, I really wouldn't comment on that. Yeah.
Well, this is a resource that's going to be embedded in the national framework for determining, in part, as a reference call of many, what is anti-Semitic and what isn't.
Yeah, sure. I mean, I guess maybe I can help here a little bit. I need to highlight my role here as well. So my role as the CEO of AHPRA is I'm not going to be investigating personally complaints. I have team members that are well trained and deal with these complaints as well. And so again, I don't know that's appropriate that I make a hypothetical outcome on the spot about whether that would be found in a particular way.
I'm not asking you to, sir. My question was not, is a complaint about this particular statement going to be substantiated? My question was, one way of reading this by a practitioner could be that there's been a determination by this handbook that referring to those three expressions is anti-Semitic. Do you think that's an open interpretation for a practitioner?
Sorry, can you, I'll get you to repeat the question.
One way of reading this handbook, which has been advertised as a resource for determining whether something's anti-Semitic or not, one reading of this by a practitioner could be that use of those three expressions has been determined by this handbook to be anti-Semitic.
Can you repeat the three expressions that you're referring to?
Ethnic cleansing, apartheid and genocide.
Again, I think what's important is it comes down to it really comes down to the facts and evidence that are in front of us, right? It really does. It's very difficult to generalise about a term or several terms will be construed in a particular way. I think it all comes down to context.
It comes down to context.
It does, and again, that's why the role that we're playing here, importantly, is to ensure that we are building the right public guidance as well.
Yes.
To ensure that we can support practitioners to know where that line is and where that line might be crossed. And again, I want to reiterate, we as a regulator have no interest in interfering with expressions of political expressions or other, as long as they are, again, accurate and they don't discriminate and that they're not, they don't cause racism.
Yes.
It is not to interfere with public speech, general public speech, but what we would do in that situation is we would have a dedicated team that would be looking at those matters and looking at all the evidence that surrounds that.
Can I, at the end of my questions, I'm going to put some proposals to you about how guidance could be given to practitioners, but if I could just continue for the moment. Prior to the publication of this handbook, in January 2024, the International Court of Justice ruled that it was plausible that Israel's act in Gaza could amount to genocide.
I object. I object. We respectfully submit that this commission ought not be used as a platform for referring to such allegations. My friend is wrong. That's not what was found, and the suggestion is in any event irrelevant to the Commission's terms of reference. It could only be relevant to the subject of the Commission's terms of reference in fueling anti-Semitism and eroding social cohesion for these false claims to be advanced through this forum.
Mr. Borski, as I understand where Ms Edwards is going, it is to contend that in some contexts, use of the word genocide, which is a very loaded expression, might nonetheless not be evidence of hostility towards Jews, but might reasonably be taken as a political statement about the conduct of the State of Israel. I think that's where she's going, and I understand the sensitivities, Mr. Borski, but this is very much at the heart of aspects of the work of this commission.
Commissioner, with the greatest of respect, we understand and accept that, but accuracy matters and truth matters, and what my friend put was inaccurate. It was false. She put that the International Court of Justice has ruled that it was plausible that Israel's acts in Gaza could amount to genocide. That is false, and its airing in public is liable to exacerbate the problem of anti-Semitism in this country.
Yes. Mr. Borski, calling it false might be going one step beyond a neutral way of framing it. Isn't the position that by majority the court accepted that there was a prima facie case brought by South Africa, and accordingly it was disposed to grant some particular measures pending the determination of the cause of action itself? So that carries with it not any conclusion on the issue of genocide, but an acceptance that there was a prima facie case. I mean, Mr. Borski, I know the sensitivities.
I know you do, Commissioner, with respect. May I respond? That's what the that's approximately, with great respect, what the ICJ found, but that's not quite what they found. What they decided was that they had jurisdiction to hear the allegations, and that the rights claimed under the convention were plausible, and accordingly the International Court of Justice made interlocutory orders, or what the ICJ describes as provisional measures, aimed at preserving those plausible rights. And that's different to what was put to this witness, both in substance and form.
I'm just trying to turn it up, Mr. Borski.
And I don't want to argue with you. I don't want to argue with you, Commissioner.
No,
I think the point's been made.
The point is, what Ms. Edwards is seeking to put is that circumstances exist in which a person, in the course of the exercise of political speech, can express a view that the conduct of the present administration in Israel has involved genocide without evincing a perception of hatred of Jews.
Yes, without necessarily evincing that, and we accept that. That's not what was put, but we accept that proposition.
Well, if that's accepted, Ms. Edwards.
I think it's an efficient way to proceed, Commissioner.
It is.
Commissioner, could I make one submission on the topic?
Oh yes, Mr. Lancaster.
The launching pad for Ms. Edwards' questions was an example given in the ASECA handbook.
Yes.
The example does not involve express criticism using the word Israel or the government of Israel. It uses the terms Zionist, and so the launching pad for the question that does not sit well with Ms. Edwards' explanation of it.
Well, just one. If you could bear with me.
The expression is Zionist project.
Ms. Edwards, just one minute, if I could finish my discussion with my counsel assisting.
Could the page be brought up again, perhaps?
Mr. Lancaster, if you look at page 75, in the section of analysis, it reads, "Unfortunately, what followed the earlier post was a response which was anti-Semitic because it included statements that accused Israel of apartheid, oppression, racism and genocide."
Yes.
So I think...
It arises on the analysis section rather
yes.
than the scenario.
Yes. I'm sorry, Mr. Lancaster, you're right. But I suspect it's all resolved by my exchange with Mr. Borski, Mr. Borski's concession, and Ms. Edwards' acceptance of it. if we can all keep on getting on this well. Ms. Edwards.
So, Mr. Untersteiner, was AHPRA aware that there have been contexts where certain international bodies have made reference to Israel and their conduct in Gaza which has used at least the term genocide?
The extent of my knowledge is what I've read in the media, and so I can't validate what was or wasn't said by an international court, but I can say I'm aware of the commentary.
It's fair, with respect, for you to say that context is everything. But the question I'm directing to you is, when you're regulating 1 million practitioners, and those practitioners are aware that this is embedded into a national framework as a possible reference tool for determining what's anti-Semitic, that there's going to be a clear and present danger highlighted by this section that any use of those three words could potentially invoke a claim of anti-Semitism or racism against them.
Again, I'm not convinced that is how this is applying and playing out in reality. I don't. I think we've been very clear here that we are using this as a reference tool. It's not a legal document that binds us in a particular way. It's a reference tool. We use a number of reference tools, and the purpose of us using a reference tool, again, is to help guide us in terms of triage, categorisation, but it doesn't mean that it binds us to any particular pathway. And again, I go back to one of the important roles that I've got as the CEO of AHPRA is to ensure that we continue to communicate with the public about how we will or we won't be considering cases. And we've already started to give examples to ensure that we can remove any anxiety that practitioners may have, and that's our assurance.
And so on that assurance, in terms of what is and what isn't, is it the case that AHPRA is prepared to put on that social media guidance, for example, a statement that expressing views consistent with those made by an international court or a UN committee would not likely lead to substantiated complaints?
It's not something that I could commit to here in the witness box, but it's certainly something we could consider.
Would you commit to considering at least a specific guidance as to whether or not use of those three expressions will not necessarily be considered anti-Semitic, but it will always depend on their context?
Yeah. I mean, I think what we are trying to avoid doing is creating what is almost a decision tree that is binding on decisions, because what you've just applied, I'm sure we could pull out lots of things and lots of documents and so again, what we're trying to do is apply principles, again, about how we will apply definitions. And again, we've been very clear that certain expressions, certain political views do not amount to anti-Semitism. They don't. And so again...
Can I just stop you there?
Sure.
What clarity have you provided practitioners about what statements are not anti-Semitic?
We have just, again, released information in just the last week on our website.
Yes.
Further information that demonstrates examples of what would or may not constitute. Sorry, let me step back. We've updated our social media guidelines to give examples.
Yes.
But we also released further information on our website.
Yes.
Under the form of FAQs that go into further detail about the AHPRA definition and how we'd apply it. And that's just the beginning. We're continuing to do further work, and including engaging with organisations in the community that represent health practitioners to help ensure they have the right education about how we will and won't apply it.
And some of that guidance, for example, includes saying things like calling for peace or a peaceful resolution would not be considered anti-Semitic normally.
Correct.
It includes deploring a humanitarian crisis is not likely to be seen as anti-Semitic.
Correct.
But what you said in your evidence was practitioners have the right to free speech and a right to express views about it, whether it's political issues or otherwise. But that right will be constrained if it starts to lean into discrimination against an individual or a group of individuals. What, if I can respectfully adopt the Commissioner's view as the nub of this issue, is that reasonable minds are going to differ about when an expression about Israel, particularly whether or not Israel is engaging of genocide, is directing towards a group of individuals, isn't it?
Well, I would argue that in just about everything I deal with as the CEO of a regulator,
Yes.
there are always going to be different views.
Yes.
Always. We have a diverse group of practitioners, 1 million health practitioners, and it's unlikely we'll ever have a consolidated view. And that's the role of us as a regulator, right, is to navigate that and use the tools that we've got available to do so.
What I'm suggesting to you is, with that example being live and written in a declaratory format, in a resource that you say is critical to the determination of whether something is anti-Semitic, unless that possibility is taken off the table, there's a real risk people feel that they can't engage in a crucial aspect of that debate, is there not?
I mean, when I talk about that document being critical, I think it's been critical in calling out very expressly that general criticism of Israel will not be anti-Semitic. Again, that it's clear, and the adoption of AHPRA definition is not about replacing the law or our general obligations, it's a reference tool only. So it's those sorts of principles that are really important for us in making the decision. Even applying those principles that are in the handbook means that doesn't mean that we need to take every word from the handbook and use it in decision making. It's a reference tool only, and we'll use it appropriately in decision making, like we do with many reference tools. And so again, I take the point, but I think it's easy to get caught up in discrete hypotheticals, but I'm not convinced that it's a real issue. And again, though, I appreciate that we have different views in the community. And it's my role to continue to work with those different views in the community to make sure that we can provide assurances about how this will be applied.
When you say it's not a real issue, it was enough of an issue for the head of a GP association to write a letter to AHPRA raising concern about that very issue, that is the distress it was causing practitioners to go through the complaints process.
Yeah, but that wasn't about the AHPRA definition.
It wasn't about the AHPRA definition, it was about expressing concern about the situation in Gaza. It is the case, as you've referred to in your evidence today, that practitioners are concerned that they can't engage in comments that might relate to things like the International Court of Justice ruling or the rulings of various fact-finding committees of the United Nations. I mean, you're aware of that, aren't you?
Sorry, there was a
Yes.
statement that was embedded in the question that purported to summarise. Oh, I'm sorry.
Microphone, sorry.
Sorry about that.
Sorry, Mr. Jealous, go on.
The question from the mouth of the witness that in his evidence he had made a statement which I have not understood what it was to have said.
I'm sorry, I couldn't hear you then, so
I'm sorry.
we're in real strife. Maybe if you just speak up more loudly.
Sorry about that.
The question, as I understood the question that was put, suggested that the witness had agreed with the proposition in his evidence that practitioners are concerned that they can't engage in comments that might relate to things like the International Court of Justice rulings or the rulings of various fact-finding committees of the United Nations.
Yes.
And I don't believe the
No,
witness
I'm happy to
gave
withdraw
that
that.
evidence.
Yes, it's withdrawn. Thank you, Mr. Jealous.
Yes. I'll unpack it to not blur two concepts together. You indicated in your evidence today that you were aware that practitioners had broadly expressed concerns about not being able to engage in speech that might be critical of Israel.
There was some commentary to that effect.
You're aware, obviously, of the letter that was prior to the adoption of the
Correct.
AHPRA definition. So that was a concern that was live prior to the AHPRA definition.
Correct.
And you're aware that there are international courts and humanitarian bodies who have made certain comments, yes?
Correct.
You have difficulty because context is everything, but you're not in a position where you're prepared to give an ironclad guarantee that merely expressing agreements with those particular findings would be off the table in terms of what might be substantiated as a complaint.
I mean, I think on the surface, if there is a ruling in the International Court and someone was to repeat that ruling, again, on the surface, I couldn't see an issue with that. But again, we would need to be looking at the specific case and the evidence surrounding it.
Given the particular example in that handbook relating to those three expressions, would it not be valid to make clear in social media guidance that is not a definitive determination, but a contextual one that would rely on a number of other factors.
Sure. Absolutely. I mean, we would be happy to consider that. I don't have any particular issue with that. Again, it's something that we would be happy to consider.
One last question. I know my friend has to have to go too. You made a reference to data scraping and reviewing social media posts for potentially racist and anti-Semitic comments. Is that right?
I did.
Does that use search terms?
So at the moment, we're in really, I don't have a lot of detail because this is really early work for us. We've engaged a service provider that undertakes general social media monitoring, and they will use a range of different methods to identify. And by the way, this isn't just about discrimination. This relates to other issues that might play out in the health system.
But what I'm asking is there some sort of input into a data scraping process? So, for example, the word genocide is flagged, and every post that makes use of that word would come to the attention of AHPRA. Is that how the process works?
I'm not familiar enough with the process to be able to answer that question.
Final question. You made reference to people with lived experience guiding your framework, and you said you've worked closely with doctors to reduce the distress they can experience through the notification framework. Have those doctors included doctors who were subject to complaints about concerns they'd expressed about the situation in Gaza that weren't substantiated?
We haven't yet finalised who we will be putting on the panel. We have already included some members who don't have lived experience, so others that will support the process, such as those that run service providers and others. But at the moment we're more broadly engaging with different community groups to understand how we might approach people, because again, one of the things we're very mindful of is we don't want to be in a position where we cause further trauma to an individual that's had trauma. So we've been very careful about our approach there to make sure we get the right mix of people and we do it in a way that's trauma informed and safe. But we haven't yet made a final conclusion about who would be included.
Do you see the utility of including someone who's gone through that process?
Oh, I do, yeah.
Thank you.
No more final questions, Ms. Edwards. Mr. Borski.
Thank you. Mr. Untersteiner, my name is Sonia. I'm here for 7 Jewish community organisations in this commission. Now, you gave evidence in answer to Senior Counsel Assisting that it was around mid-June this year that AHPRA adopted the definition of antisemitism. That's right?
Correct.
Sorry, I've been asked to pause.
It's not a conspiracy against you.
I didn't suspect it. The sensitivity doesn't go that far. Now, in mid-June this year, you adopted the AHPRA definition, correct?
That's correct.
And that adoption was taken after work you did with the Special Envoy to combat anti-Semitism and consideration of the handbook that she released this year?
Correct.
And you AHPRA only adopted the definition as a reference tool, is that right?
Correct.
So it's not part of an approved registration code at this stage?
That's correct.
And so it follows from that it is not deemed to be evidence in disciplinary proceedings under the national law?
That's correct.
And having considered the Special Envoy's handbook and perhaps other things, you became satisfied that criticism of Israel similar to that levelled against any other country is not to be regarded as anti-Semitic according to the AHPRA definition. Is that right?
Correct.
And you and AHPRA recognise the importance of freedom of political expression and advocacy?
Absolutely.
But on a proviso that what might be said in some quarters to be free speech does not stray into discrimination or abuse. Is that right?
That's correct.
On the subject of abuse, In response to AHPRA's adoption of the AHPRA definition as a reference tool, you personally and AHPRA and the Special Envoy have been subjected to quite unsavoury attacks and abuse online. Do you agree with that?
That's correct.
You have been accused of supporting genocide by Israel, correct?
Correct.
You've been accused of having been bought out by the Israel lobby and the Zio-Nazis, correct?
Correct.
It's been said online that this, your organisation's adoption of AHPRA, is part of the Zionist terrorist invasion supported by the Prime Minister and the Royal Commissioner, all of whom are traitors to this country, correct?
I haven't seen that one, but it's consistent with other posts that I've seen.
We might seek to tender that. I don't want to call it up on screen if the Commissioner pleases. We might seek to tender that through Council Assisting later. And online posts expressing even more vile abuse have been made towards the Special Envoy as a result of AHPRA's announcement that it adopted the AHPRA definition as a reference tool, correct?
That would be a question for the Special Envoy.
You haven't seen the posts that suggest that the Special Envoy should have been gassed and should have been at Bondi on the 14th of December?
I haven't seen that, no.
And you've also come under heavy pressure from unions in opposition to AHPRA's adoption of AHPRA as a reference tool, haven't you?
I've received correspondence from several unions who have requested that we pause the use of the AHPRA definition.
You're more delicate than I, Mr. Untersteiner. Will these communications deter you or cause you to reverse your decision to adopt AHPRA as a reference tool?
No, it won't. I mean, I think as a regulator of 1 million health practitioners and a regulator that supports an even larger community, again, we will face into community issues where there will be difference of opinions on a range of issues. And the role that we've got is to make sure that we are considerate and diligent in making our decisions, that we consider different perspectives, and then we make decisions that are right for the community and public safety. And I'm confident that we've done that. And so as a result, we will not be changing that decision. However, it remains important, as I mentioned in the previous line of questioning though, that we do play a role in helping to educate practitioners about the real application of the AHPRA definition as it relates to the health practitioner regulatory system, to ensure that we can remove any misconstruction of how we will apply that. And that's the role we'll play, and we will continue to work positively with unions and with other groups to ensure that we can do that. So all practitioners understand their role in the system. And again, we can correct incorrect information that might have come out, sometimes deliberately, but sometimes not, through genuine misunderstanding.
On behalf of the mainstream Jewish community organisations, Mr. Untersteiner, thank you very much.
Thank you.
Mr. Jealous.
Just very briefly, Commissioner, I know the time and I know there's another witness waiting, so I will be very quick.
Yeah, do go on.
Thank you.
We sit irregular hours on occasions.
Mr. Untersteiner, just very briefly, you were asked about whether it was about the idea of an ironclad guarantee that the use of certain expressions such as genocide might or might not be anti-Semitic. You remember the questions that you've been asked along those topics. And I think that part of your answer was that the use of these terms and the permissibility of the use of these terms by registered health practitioners may depend on context.
Correct.
What are the kind of contextual facts that might be relevant to an investigator who's dealing with a notification that involves the use of words like, for example, genocide?
Well, again, it depends on the surrounding circumstances of the statement. So it depends on where the statement was made, but what is attached to that statement as well. And so to simply refer to repeat, for instance, I'll use a hypothetical here. If someone was to repeat the findings of an international court that had identified or suspected genocide, that on its own I couldn't imagine would draw our attention. But if it's in a context where it's also using other terms which are clearly drawn together, create discriminatory language, that would be different. And so, again, accusing whole groups of individuals or using derogatory terms associated with genocide will be very different. And so that's why it's hard to answer that question, because it all depends on the circumstances and the evidence that is in front of us. But using the term genocide in isolation in a factual way would not be, again, on the surface, an issue.
Well, the focus of this part of the questioning seems to have been social media, but the AHPRA definition will be applied in assessing notifications about both social media and things that occur in other places. Is that correct?
Correct.
And so is another relevant context likely to be the forum in which these sorts of things are said?
Of course.
And is it possibly the case that the line might be drawn differently, for example, where terms like, for example, genocide are used in a workplace or with a patient as opposed to particular kinds of social media posting?
Again, that's exactly right. It's all about context and the situation. The situation that is in front of us.
And just finally, you referred to some of the training that investigators, those involved in the notifications team, and also senior leadership have done with various Jewish groups and organisations in order to better understand anti-Semitism.
Correct.
In the course of that further education and training, has the significance of phrases like genocide been something that's been discussed by the Jewish community with you?
Again, in the training that we've done, it all related to context. And I think that's the message that we continue to receive. I mean, we undertook really significant training with the Australian Centre of Jewish Civilisation. And in fact, we also undertook significant training with the Islamophobia Register of Australia, and I would argue that both parties had the same view, which is a word, not always, but in many cases, a word, for instance, can mean very different things in different circumstances. And it always comes down to contextual factors. What we go back to, though, and this is really important, is again we go back to our codes of conduct, which focuses on eliminating racism and discrimination in the health system. Right, and so we go back to those broad principles that sit within the codes of conduct, and then we apply that as we look at this. So again, the circumstances will vary, and I would also argue that there have been times where we've seen practitioners who like to rely on a free speech argument when in fact the intention had nothing to do with free speech. The intention was about racism and discrimination. And not just in the context of anti-Semitism. We've seen that in other contexts too, right? And it worries me deeply to hear stories, and I've been listening to the Royal Commission and hearing real stories of people who are fearful to go and get the help that they need in the health system. And so I don't apologise for the work that we do. And again, I stand by. We will not be interfering with free speech that is done accurately and safely. But again, when that draws into discrimination and hatred, we are likely to have a problem.
Has the view been expressed to you that less than 100 years on from the Holocaust, and with Holocaust survivors still alive within the community, terms like genocide are words that can be very harmful depending on the context to Jewish people?
It could be, yes.
I have no more questions.
Mr. Chairman, anything arising? Thank you.
Thank you very
are
much.
excused.
Thank you.
We're sitting on, Mr. Lancaster, are we?
I understand Ms. Marshall, who's the final witness, is available to sit on. So if
yes, indeed.
We can proceed.
Oh, certainly, Mr. Jealous, yes. And you, Ms. Edwards.
you swear by Almighty God that the evidence you shall give will be the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Take a seat.
Ms Marshall, please state your full name.
Sonia Marshall.
Your address is known to the Royal Commission. You are the Chief Executive of the South Western Sydney Local Health District.
That's correct.
You've prepared a written statement dated 9 July 2026.
That's correct.
Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes, it is.
Commissioner, I tender the statement. It is STAT.899.0102.0002.
Yes, the statement will be admitted.
Ms Marshall, you've been employed with the South Western Sydney Local Health District since about August 2016.
That's correct.
Initially as the Executive Director of Nursing.
Correct.
And then you were appointed Acting Chief Executive in September 2023, which became permanent appointment to the role of Chief Executive from January 2024.
That's correct.
And your responsibilities include the strategic leadership, direction and management of the local health district, the South Western Sydney.
That's correct.
Could you identify the LHD, what hospitals are comprised within it, and the size of the population that district services?
So South Western Sydney covers the hospitals of Bankstown, Liverpool, Fairfield, Campbelltown, Camden and Bowral. We cover 7 LGAs and a population of the last census close to 1.2 million people.
And you've described that local health district's population as extremely diverse?
That's correct. 39% of the population reported in the last census that they were born overseas.
And culturally and linguistically diverse as well?
Correct.
Yeah. In terms of the census, identification of those who identify as having Judaism as their religion, it's about approximately 500 in 2021?
That's correct.
And another couple of hundred in the census identified Jewish heritage.
Yes.
You've said in paragraph 12 of your witness statement that while the LHD's Jewish and Israeli population make up a small percentage of our diverse culture, it's incredibly important to us that patients from all backgrounds and cultures, no matter how small, feel supported and cared for in accessing health care within the district.
Yes, that's correct.
Now, your statement addresses in some detail the incident in February 2025 that involved nurses at Bankstown Hospital.
That's correct.
That matter is currently before the courts.
That's true.
Yeah. So I will not ask you about the incident itself, but your statement addresses a series of measures taken by the local health district after February 2025 to address the expression of politically charged or politically motivated commentary in the context of healthcare services.
That's correct.
So you have described firstly a series of internal communications with staff about expectations for patient safety and additional measures for staff well-being. What is that focused on?
So the in terms of the staff well-being, is that what you're referring
Yes.
to? Making sure that all staff feel supported in the workplace. Following the events of February 25, staff, particularly in Bankstown and those from various cultures, felt both embarrassed and ashamed in the workplace. They were vilified in the community. for working in southwestern Sydney, particularly those staff who worked at Bankstown Hospital. So providing support to the staff was really important to ensure that they could continue to come to work and provide safe quality healthcare.
Your statement also refers to a number of video messages that have been prepared and published. One of the video messages was involved the participation of Rabbi Kastel and senior Muslim chaplain Mohammed El Shafei. Is that right?
That's correct.
How was that video received, to your understanding?
Largely it was received very well in the community. There were a couple of comments when it was posted on social media that had to be removed, but overwhelmingly there was quite good support.
The Ministry of Health more broadly has issued a We're Here For You campaign.
That's correct.
So it's not limited to southwestern Sydney?
No, that's for all of New South Wales Health.
Could you describe what's involved in that campaign?
Yes, so the We Are Here From You campaign is involving a number of different aspects. So firstly, a number of videos were released in February and March of 2025 from staff of various backgrounds making statements to camera about we're here to provide care to all members of the community, regardless of what race or culture or religious beliefs that you might hold, to try and provide community with reassurance that despite what had been posted online by those two nurses, that everyone could feel comfortable in coming to their local hospital to receive the care that they required.
In March this year, there was also a launch or relaunch of a campaign that was called Raise It.
That's correct. Raise It is the transformation or the refresh of the REACH program, and it is aimed to ensure that patients, their families and loved ones can raise concerns in the first instance to their healthcare worker or their care team, and then more broadly, if they don't feel if they feel that their loved one is deteriorating, or that they're not getting the information that they need from their healthcare team, it allows some different steps to allow them to have avenues to raise their concerns if their loved one requires additional assistance.
So, in terms of the Raise It campaign, what is being said to members of the public who might attend a healthcare team or healthcare professional? What is the process that's described to them?
So there's been a significant amount of both social media and media more broadly, both in general media as well as in language media across New South Wales, to advertise the refresh of the program and to make sure that people are aware that they can call a central number to raise concerns or talk to their healthcare team. So we have done, or New South Wales Health as a whole has done some videos to introduce members of staff, so the nursing unit managers or the midwifery unit managers as points of contact, for example, who are on each of the care wards in hospitals as a first point of contact. Then they have put together a portal, We're Here For You portal, where patients, families can, or members of the public can access to find further information about things such as accessing pastoral care or quiet spaces within hospitals.
Thank you. In paragraph 13 and the following paragraphs in your statement, you've addressed the expectations of the South West Sydney LHD staff, and you've referred in paragraph 13 to 4 different policies that apply to or potentially apply to staff behaviour. chief among them is the New South Wales Health Code of Conduct.
That's correct.
And the Code of Conduct is something that is binding on staff members as a matter of their employment contract, is that right?
That's correct. So every staff member who is employed by New South Wales Health receives a copy of the Code of Conduct and signs on their employment contract that they will abide by the conditions in the Code of Conduct.
Can I ask you about the code? So it's SWS.0001.001.0041. Now, this front page refers to its publication date as date in December 2015 and a review date December 2020. Is this the currently applicable code, as you understand it?
The Code of Conduct, yes, it is, correct.
And if I can just take you to page underscore 0010, section 4 of the code. Under the heading 4 Code of Conduct, it indicates that the code requires staff to adhere to the standards that are set out below, and as you've described, this is part of their employment.
That's correct.
Requirement. And then at 4.1.3 is the prevention of or the principle against bullying or harassment of either staff, patients or members of the public, including on discriminatory grounds.
That's correct.
And anti-Semitism doesn't figure in terms in there, but it's clearly captured in the list. Would that be your understanding?
That would be my understanding.
And then if I could take you over to page 0012, section 4.3.1, that requires staff to act in a way that provides a safe and supportive environment on its premises for patients and their family members.
That's correct.
4.3.4, which I'll come back to in relation to another policy, but that requires dressing in a way that's appropriate for the work they do.
That's correct.
And then over the page, 4.3.16, when making public comment on issues or participating in political or industrial activities, not indicate or imply that their views are those of New South Wales Health.
That's correct.
And then 4.3.17 is another obligation, which is to carry out their duties in a politically neutral manner.
Correct.
Is guidance provided by the Ministry of Health or by the LHD to staff members in relation to those particular obligations that I've drawn your attention to?
So through orientation, staff are briefed on the Code of Conduct in general form, specifically not calling those out, but making sure that they're aware that they have to understand and abide by the Code of Conduct in its completeness through the course of their employment.
And once their employment is underway, is there any process that the LHD applies, or the Ministry of Health more generally applies, to staff members to refresh or renew that understanding of their obligations under the code?
Yes, so there are mandatory training requirements that staff have to undertake, and as part of that, the Code of Conduct training is part of that mandatory requirement.
So how often would that occur?
That occurs, it's supposed to occur within the first 3 months of their employment with New South Wales Health.
And is it something that occurs again in the course of their employment?
Not unless it's deemed required by the individual through a process.
So is there any other less formal way in which these Code of Conduct obligations are drawn to the attention of staff, or are they given reminders about this?
Yes, so throughout the course of care provision and throughout the general hospital run-ins or the health service run-ins, we'll do focused activities. So 1 month might be on the code of conduct, the next might be on the social media policy. We might run webinars for different things. So both at a LHD level, but also at a hospital level, managers are encouraged to be having conversations in their monthly meetings, depending on what's going on in the workplace at the time.
And are those various mechanisms by which they might become refreshed in their understanding of the code of conduct, are they voluntary or are they required to be undertaken by staff members?
They're voluntary.
Is there any mandatory process for refreshers about obligations under the various policies that the LHD applies?
In terms of if there's been a process whereby someone's determined through either a misconduct or a performance improvement plan that an individual or a team requires a refresh, then they'll be directed to undertake a refresh of that mandatory training.
Apart from circumstances where there's, by the sound of it, an established complaint against a particular staff member, is it right that there's no other process for regular reminders or refreshment of the understanding of staff members about these obligations?
Through their annual performance conversation with their manager, the manager is obliged to talk to the staff member about reaffirming that they are required to work to the code of conduct and all of New South Wales health policies.
See. Can I then ask you about one of the other documents that you've referred to in paragraph 13 of your statement, which is the policy directive about prevention and management of unacceptable workplace behaviours?
Yes.
And so this is document SWS.0001.001.0040. This applies to conduct both in the workplace but also outside of work hours or locations if there's a connection to the workplace, is that right?
That's correct.
So what sort of events outside hours or outside the workplace would be included?
Any event where a staff member engages in a behaviour that is outside or a breach of the code of conduct.
I'm asking in what circumstances would this policy document about unacceptable workplace behaviours apply to the conduct of staff members outside actually being at work during working hours?
At work outside of work hours.
Outside, yeah.
It's, and I'm not sure I quite understand your question, but in terms of if the individual's behaviour outside of the workplace brings New South Wales Health into disrepute or poses a risk to the reputation of New South Wales Health or breaches policy, the code of conduct, this policy would come into place.
This policy includes within the notion of unacceptable workplace behaviours, it includes inappropriate comments or conduct based on adverse comment on race or ethnicity or religion, is that right?
That's correct.
And if there were a complaint that a staff member had conducted himself or herself in contravention of this policy or indeed of the Code of Conduct, is there a process by which those complaints are recorded and actioned?
Yes, we have a very clear policy. It's assessed in terms of the behaviour, so dependent on the behaviour or the alleged circumstances of the event, the seriousness of the event or behaviour would be assessed, and then dependent on a risk assessment undertaken at that time around the behaviour, and the implications and what policy or procedure that breaches then depends on whether we would follow a grievance policy, whether it's handled in an informal manner or whether a more formal policy would be applied.
And is that handled in the first instance at the local health district level?
So in terms of incidents raised, it would be handled at the lowest level possible, depending on the seriousness of the event or the behaviour. So in most cases, it's handled at the hospital or health service by the local team. In more significant cases, it would be handled at the local health district level by more senior staff. And there are other escalation pathways should that be required.
Would each of the hospitals, or do each of the hospitals in the southwestern Sydney LHD have their own complaints and investigations unit?
Yes, they do.
And what sort of numbers of staff are involved in those processes?
In the first instance, complaints are handled at the unit level, so by the nursing unit manager or the cost centre manager, to try and manage it at the lowest level possible, with support from either the human resources, if it's a workplace grievance, if it's around misconduct or a complaint about patient care, then professional leads may get involved, so directors of nursing, directors of allied health, directors of medical services to provide that assistance. So depending on the size of the hospital, depends on the size of the team involved in supporting the investigation or the concerns.
As you've indicated, there's also a policy in respect of using social media.
That's correct.
And can I ask you some questions about that policy directive, SWS.0001.001.0043? If we could go to page 0002. The third paragraph under the heading Policy Statement indicates that it applies to all New South Wales Health staff, including employees, contractors, visiting practitioners, volunteers, students, researchers and trainers.
That's correct.
So that essentially covers the field of everyone that a member of the public might encounter in a hospital visit.
That's correct.
And if we could go to the next page 3, please. It describes, under the heading Personal Use of Social Media, that staff have a right to use social media in a personal capacity. They shouldn't imply they're speaking on behalf of New South Wales Health.
That's correct.
That's the first principle. And then in the second paragraph, staff must not post, support, share or like content that is offensive, obscene, derogatory, defamatory, threatening or hateful, or reasonably likely to cause serious harm.
That's correct.
And does that refer to even to all personal use of social media?
That's correct.
Whether or not they might be understood as speaking on behalf of New South Wales Health or not?
That's correct.
And then the final part of this obligation is staff must not post photos, videos or information about other staff patients or members of the public without their consent.
That's correct.
And then, can I take you over to page 9? Under the heading Key Principles, one of the principles addressed here is in the use of social media is to remain apolitical and impartial.
Correct.
And then if I could take you over to page 11. These are key principles for personal use of social media, whether or not it purports to be a statement that's on behalf of New South Wales Health. Is that right?
Sorry, could you just repeat that again?
Yeah. So the key principles in section 4.1 include obligations for the purely personal use of social media?
Yes.
And the third and fourth bullet points under that heading I won't read out, but they reflect the earlier principles about what's not to be done.
That's correct.
Now, what, if any, regard does the local health district have to definitions, for example, of anti-Semitism or other forms of discrimination? What resources are used to understand whether that conduct has occurred?
So we use all of the New South Wales health policies, so we do not have a specific definition of anti-Semitism as outlaid in our policies. We use the ones that have been provided in my statement, but any conduct that someone would perceive to be discriminative, we would investigate those concerns.
And you referred to the use of the policies that are set out in your statement. Those documents don't seem to include particular definitions either of discrimination or of anti-Semitism. Is that right?
That's my understanding.
So when there's a complaint and it's considered at the local health district level, it's carried out, is it, by staff members on their general understanding of discrimination and anti-Semitism?
That's correct.
Now, one of the questions asked of the local health district by the Commission was to identify policies with respect to political neutrality of staff in the workplace. The social media policy explicitly refers to that. That also applies to clothing and uniform?
That's correct.
And there's a specific policy also on that topic?
Yes, that's correct.
And can I take you to that? It's SWS.001.001.0073. So this is not Ministry of Health wide, this has a particular application to your local health district?
That's correct.
It is the case though that some other local health districts have also adopted a uniform and clothing policy?
That's correct.
And if I could take you to section 2, which is on page 0005. That identifies the aims and expected outcomes of the policy, including the presentation of a professional image at all times and compliance with section 4.3.4 of the Code of Conduct that I took you to earlier in respect of appropriate dressing.
That's correct.
Can I just ask you about some of the details that are set out in the policy? So at the foot of this page 5, items that compromise patient or staff safety mustn't be worn, so there's some limitations on jewellery that might actually physically affect the provision of care.
That's correct.
And then there is a permission in the final bullet point to wear clothing or jewellery that could be considered to have a cultural or religious significance, provided it doesn't pose a safety or health risk.
That's correct.
And then over the page is quite detailed guidance about offensive or prohibited body art.
Correct.
Yes. Can you summarise the effect of those restrictions?
Anything that might be found to be offensive, whether that be graphic depictions of nudity or signs of racial or ethnic, religious slogans that would cause offence.
They need to be covered during
Correct.
working place, right? And then over at section 4.4 on page 8, this is in respect of staff who are not required to wear a uniform. There are dress standards about the clothing that are regarded as inappropriate.
Correct.
And that includes inappropriate or controversial commercial, religious or political messages.
Correct.
Now, when it are there examples of complaints that have been made in respect of clothing or accessories thought to breach the provisions about inappropriate religious or political messages?
Yes, and I provided in my statement 2 occurrences which we managed after the February 2025 incident with the nurses, whereby we were required to speak to 2 separate staff members regarding one, a pin that one staff member was seen to be wearing in the workplace, and the other was in attendance in their uniform at an event that could be political or in nature.
And is your intention in managing the LHD to entirely remove political messages from the workplace in terms of clothing and accessories?
That is the aim.
The SES policy, the South Eastern Sydney Local Health District policy, refers explicitly to a prohibition on wearing or displaying symbols, badges, clothing or accessories that carry political, ideological or activist messages. Are you aware of that?
I wasn't aware of that.
My question is the South Western Sydney, your local health district policy, is it limited to uniform and clothing, or does it extend to, for example, accessories or items that people might put on their desk or workstation and the like?
Yes, it also covers pins, and the code of conduct would cover if someone was putting some form of discriminatory or antisemitic displays in their workplace or on their desk.
Now, you've also identified a cultural change initiative called Better Together that is recently introduced, is that right?
That's correct.
So when has that been introduced to the South Western Sydney LHD?
So it's been nearly 2 years now.
And could you explain the intention with that campaign?
Better Together is around helping all of our staff understand collectively that we need to break down all of the actual or perceived silos that we create. So it first came about trying to ensure that professions didn't exclude each other, and then we've gone more broadly in terms of working with and alongside our communities. So trying to ensure that people from all professions, races, religions and cultural and ethnic backgrounds are included in both the workplace and the care that we provide. So Better Together is a philosophy that we are trying to embed with our staff to ensure that regardless of whether they work in a hospital or community, that they're thinking about who they should be having conversations with and including in the care environment when they're delivering that care.
So as a practical matter, what sort of steps or functions or events do you carry out to try and implement that kind of change?
So we have done a number of things. So we have CE messages, of which I record every Monday morning or first working day of the week, and talk about different things occurring across the LHD. That goes out to all staff. We have CE or leadership chats where our leaders in the different sites and services can come together, and we talk about how we can ensure that they can include either members of the community, different cultural groups, or other facilities in care planning and service planning, as well as looking at when we are having all of our meetings, who else needs to be involved, and when we're developing models of care, what community members or different staff need to be involved in that.
You've referred to some Ministry of Health-led initiatives aimed at strengthening culturally safe care, which apply also in your health district.
That's correct.
One of those is the New South Wales Health Multi-Faith Resource Hub. Could you explain what that is and how, to your observation, that has operated?
Yes, so out of the We Are Here For You campaign, the Multi-Faith Hub provides a central place where community can go to get information about accessing chaplaincy services or quiet reflective spaces in hospitals, or who to contact should they need, they can't find a space and need a space.
You referred to the chaplaincy function. That's a statewide initiative that involves access to the chaplaincy community. Is that right?
That's correct.
And so how does that work? If you're a member of the public or a patient's family member, how does that resource get accessed?
So when a patient comes into a hospital, they can identify that they are of a religion, and they can then be offered or access chaplaincy services in the facilities where they're being provided care.
Thanks, Ms Marshall. I don't have any further questions, Commissioner.
Yes. Yes, thank you, Ms Marshall. You are excused. And I'll now adjourn the Commission until 10 a.m. tomorrow morning.